And then Mr. Velasquez, when Ms. Morales shows up, is ready to go too.
So both your cases are inmates?
Yes.
Okay. Osceola Jail, can you hear me? All right. Let's go ahead and call up. Tell me your client one more time.
Michael Booker.
Okay. Michael Booker.
And Your Honor, this is definitely a plea. I just like to put something on the record before we start.
Okay. We'll go ahead and swear Mr. Booker in to start.
Raise your right hand, please. You do solemnly swear or affirm the testimony you're about to give in this case is the truth, the whole truth, and nothing but the truth, so help you God?
All right. Good morning, sir. Tell me your name and your date of birth.
Michael Shane Booker, 6/27/77.
All right, Mr. Booker, you're currently in custody on this case, and you're currently charged with 5 crimes. Count 1 is aggravated assault with a deadly weapon. Count 2 is aggravated assault with a deadly weapon. Count 3 is aggravated assault with a deadly weapon. Each of those is a third-degree felony. Each of those punishable up to 5 years in prison. Count 4 is possession of firearm or ammunition by a convicted felon. That's a second-degree felony with a punishable up to 15 years in prison, and there's a minimum mandatory sentence associated with that. Count 5 is discharging firearm in public, a first-degree misdemeanor, punishable up to a year in the county jail. Do you understand the 5 crimes you're charged with, sir?
Yes, sir.
All right, Ms. Shields, what do you want to put on the record?
All right, Your Honor, during the course of the plea, I know we discussed this at pretrial, and I know your general position. However, we are going to ask at the end of the plea colloquy for a furlough for a week. I'll address that. Mr. Booker would like to address that as well. But regardless of your decision, it's not going to change the plea. We're going to move forward.
All right. So, Mr. Booker, do you understand that your lawyer is going to take some testimony from you in the hopes that I will agree to somehow release you in some way so you can take care of some things over the course of the next week? Do you understand that?
Yes, sir.
Do you understand that when this issue was brought up to me before, I indicated to your lawyer that I didn't think it was likely that I would grant that request?
Yes, sir.
And do you understand that I'm not promising, if you plead today, that you're going to get out? Do you understand that?
Yes, sir.
All right, I'll hear what you have to say, and I'll consider it, but I just want you to understand there's no promise. In fact, I think the only safe thing for you to assume is that I'm not going to grant a furlough. Do you understand that?
Yes, sir.
And understanding that, have you decided it's still in your best interest to proceed forward and enter a plea today?
Yes, sir.
All right, Mr. Shields, what's the proposed resolution?
Your Honor, he's going to plead no contest as charged in count 1 and no contest as charged in count 4. Count 4 is a 3-year minimum mandatory sentence. So on count 1, he's going to be adjudicated guilty, be sentenced to 3 years, Department of Corrections, with credit for 190 days time served. Court costs, cost of prosecution, a $250 attorney lien. In count 4, he would be adjudicated guilty, be sentenced to 3 years, Department of Corrections. Those 3 years are minimum mandatory. Those counts are to run concurrent with each other. Counts 2, 3, and 5 would be dismissed pursuant to the plea.
Who's the state?
Cynthia Gonzalez on behalf of the state of Florida.
Is this your agreement?
That is correct, Your Honor.
And Mr. Booker, is this your understanding?
Yes, sir.
And is this how you want to resolve your case today?
Yes, sir.
Sir, as you stand here today, are you under the influence of any drugs, alcohol, or any other medication?
No, sir.
Have you ever been treated for a mental illness, an emotional disturbance? Are you suffering from such at this time?
No, sir.
Do you read and understand the English language?
Yes, sir.
In your case, I've been given a 4-page document. I'm going to hold it up. I don't expect you to read it from the camera, but it's a 4-page document called a plea form. I see that it's got your name on it, your case number on it, the charges you're pleading to, the resolution, all your rights. Did you go over this form with Mr. Shields?
Yes, sir.
Did he explain to you all the rights you have and the rights you're giving up by entering this plea today?
Yes, sir.
Did he answer any questions you had about your rights?
Yes, sir.
Did you go through the form, initialing each paragraph indicating that you understood what was explained in that paragraph?
Yes, sir.
Did you sign on the last page?
Yes, sir.
Do you understand you're entering a plea today, which means we're not going to have a trial, and I'm going to sentence you today?
Yes, sir.
Has anyone forced, threatened, or coerced you to enter this plea today?
No, sir.
Other than what we've discussed here in open court, has anyone made any other promises to you about the sentence you would receive, on whether I'm going to give you a furlough or not, anything like that?
No, sir.
Are you satisfied with the work Mr. Shields has done in handling your case?
Yes, sir.
Do you understand, sir, if you were not a citizen of the United States, entry of this plea would result in your deportation?
Yes, sir.
Ms. Gonzalez, factual basis for counts 1 and 4?
Yes, Your Honor. On November 17, 2019, the victim, Jessica Bernstein, who the defendant shares a child in common with, was at her residence, at which point she heard banging on the door. When she looked outside, she observed Mr. Booker standing and yelling with a silver handgun. He proceeded to point the gun in her face and yelling and screaming threats. There were other individuals present, at which point he also threatened their lives with the handgun. Ms. Bernstein was able to shut the door, at which point Mr. Booker then discharged the weapon outside up into the air. Mr. Booker is a previously convicted felon as per case 49, 2011 CF 3493. All of this occurred in Osceola County, Florida.
Any objection to that factual basis for purposes of this plea, Mr. Shields?
No, Your Honor.
Sir, I'm going to accept your plea. I find you alert and intelligent. Your plea is freely and voluntarily entered. You understand the nature of the charges against you, and you're represented by competent counsel with whom you say you're satisfied. I also find a factual basis for the acceptance of the plea. Is there any legal reason why sentence should not now be imposed, Mr. Shields?
No, Your Honor.
Mr. Shields, what do you want to present on the issue of your request for furlough or some other form of release?
If I can just inquire very briefly.
Go ahead.
Okay, Mr. Booker, prior to being arrested, where did you live?
I live in Lake County, Florida.
Do you remember the address of the apartment?
Yes, sir.
What is it?
1364 Rain Tree Bend, Claremont, Florida 34741.
Okay, and who did you live there with?
My mother-in-law.
Okay, and do you have a fiance there as well?
Yes, sir.
Okay, and what are their names?
Wendy Franco,
Okay, and what's your mother-in-law's name?
Gladys Franco.
Okay, and how long have you lived with them?
A little over a year and a half.
Okay, I know that you're here on this case today. When was the last time that you recall being involved with the court system? It's been several years, correct?
Yes, sir.
When was the last time that you can recall having a case with the court system in any county?
2011.
Okay. Miss Franco and your mother-in-law, are you the general means of support for them?
Yes, sir.
Okay. And are there animals or other issues that you yourself need to get rectified before you go to DOC?
Yes, I have a couple reptiles and a dog.
Okay. Are the reptiles yours personally, or?
Yes, sir.
All right. What kind of reptiles, and what do you need to do with those?
I have an African ball python and a ball python that I need to get rid of.
Okay. If you had a chance for a week, would you be able to find a proper home for those reptiles?
I should be able to, sir.
All right. Is this something that does Miss Franco like the snakes?
No, sir.
All right. Would she be in a position to find a new home for them herself?
She's kind of scared to handle them, sir.
All right. Who's been watching them while you've been in custody?
My brother-in-law.
Okay. Also, you have family members. You have a father right now that's in the hospital. Is that correct?
Yes, sir.
What is his situation?
He just had a hip replacement.
All right, and he was put under sedation or anesthesia, correct?
He's in ICU right now, critical condition.
All right. Now, it took several days for him to come out of the anesthesia, correct?
Yes, sir.
Which was not what was supposed to happen.
No, sir.
And he's in a kind of a questionable state.
Yes, sir.
All right. When was the last time you had a chance to see him?
It's been a little bit over 7 months now, 7 months.
All right. If you don't have a chance to see him in the next week or two, is it possible, or is there a decent chance that he could be deceased before you get released?
Yes, sir.
All right.
And my mother, too.
All right. Is there any other reason that you would need to be able to have a week to be able to take care of some issues?
Yes, my mother was diagnosed with Parkinson's disease, and they've given her 3 months to live. So I think it's going to be a chain reaction. My father's going to go, and then my mother's going to go.
All right. Now, previously, with your interaction with the court system in Florida, had you ever been given a furlough before?
Yes, sir.
Okay, and you were told if you didn't come back, that your plea was still in force, and that if you didn't show back up, you could get the maximum penalty. Is that correct?
That's correct, sir.
And that involves an incarceration sentence?
Yes, sir.
Okay, have you ever failed to appear for court for anything in the past with those kind of issues?
No, sir.
All right. Now, you have a daughter in common with the victim, Ms. Bernstein, is that correct?
That's correct, sir.
All right. Would you be able to assure the court that you would have no contact with your daughter or Ms. Bernstein if you were given a week to get some affairs in order?
That's correct, sir.
All right. And would you assure Judge Wooten here today that if you were able to get a week, that you would be able to get your affairs in order and come back to court to be sentenced?
That's correct, sir.
And you understand that if you don't come back to court, your plea is enforced and the state can still follow up on the additional 3 charges?
That's correct, sir.
All right. That's all I have, Your Honor.
Ms. Gonzalez, any questions?
No, Your Honor, I think Mr. Shields covered it all.
Okay. And State, what's your position?
Your Honor, and I believe I indicated at the pretrial just the state's concern regarding, number one, the coronavirus, releasing an inmate into the public and then bringing him back into the jail system, in addition to the victim, particularly, who indicated to me she is afraid of retaliation. There would be a no contact order in this case because it's a DOC sentence. So if Your Honor is inclined to do that, I would ask that you implement the no contact order for as long as he's furloughed for. In addition to that, he does score a substantial amount of history. This is a downward departure. He has a substantial amount of history and he scores very high. This is a downward departure. So ultimately, I would just leave it in Your Honor's discretion.
All right. Mr. Booker, I'm going to deny your request for a furlough in this matter. While I understand these issues are important to you, I have concerns based on what's been sketched out for me that in some ways everything you know and have is coming to an end. And I find in my experience that when people sometimes are faced with that circumstance, they effectively say they've got nothing to lose. And therefore, I'd have concerns about your decision-making under the circumstances while you're out. So I've considered it, but I am denying the request. At this time, I'm going to impose sentence as to count 1. I'm going to adjudicate you guilty. I'll sentence you to 3 years in the Department of Corrections with credit for 190, that's 190 days time served. I'm going to order that you pay all statutorily required fines, fees, and costs associated with that count. I'm also going to order on count 4 that you be adjudicated guilty, you be sentenced to 3 years in the Department of Corrections. That's a minimum mandatory sentence for the actual possession of a firearm as a convicted felon. I'll give you credit for 190 days time served on that count as well. The sentences on counts 1 and 4 are concurrent with each other. I'm going to order, again, that you pay all statutorily required fines, fees, and costs associated with count 4 as well. Madam Clerk, can you announce all of the costs for these 2 counts?
$415 court costs, a $3 teen court fee, $201 ag assault surcharge, $100 cost of prosecution, and a $250 contract attorney lien, for a total of $969.
Sir, I'll give you 90 days from your date of release to contact the clerk of the court, set up a payment plan, and begin making payments at a minimum rate of $30 a month towards your costs until your costs are paid in full. State, do you have an announcement on the remaining counts?
Mr. Honor, as to counts 2, 3, and 5, state would announce a null pros. And I'll follow that up electronically.
Ms. Shields, anything else?
Yes, Your Honor. I know that, is it possible that you can order him to be held just for 1 more week in the county jail before he gets taken to DOC? The reason being is he'd like to contact he doesn't know when DOC is going to come grab him. He'd like to be able to make some phone calls to get his situation. I know when they move him up, sometimes they don't let him call right away. Is it possible we can just have him held for 1 more week?
Mr. Shields, I'm not sure that that's really in the gambit of my authority. I don't have any additional proceeding for him to attend. I don't expect they're going to get him in a week, so I think it's probably not an issue, but by the same token, I don't think it's appropriate for me to tell the Osceola County Jail to hold someone when they could go to DOC and incur additional expenses and manpower effectively guarding him so he can attend to purely personal matters.
Okay, I understand.
I'll decline that request. Madam Clerk, anything else?
No, sir.
All right, that's the judgment sentence of the court. Defendants remain in the custody of the Department of Corrections at this time.
Thank you, Judge.
You're welcome.
I believe we're ready to go, Mr. Velasquez? Yep, we're ready to go, Mr. Velasquez as well.
Okay, give me a second. Tell me your client's name again.
Jose Velasquez?
Does he need an interpreter?
No, Your Honor.
Let's call up Jose Velasquez.
May I approach the plea form, Judge?
You may.
No, sir. I haven't done it.
Ms. Gonzalez, I didn't have a score sheet on Mr. Booker's case. Can you, or
No.
Mr. Shields, provide that?
You were gonna provide one, but I said it didn't happen.
Oh, okay.
She's gonna give it to you.
All right, let's go ahead and swear in Jose Velasquez.
Raise your right hand, please. You do solemnly swear or affirm the testimony you're about to give in this case is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Good morning, sir. Tell me your name and your date of birth.
My name is Jose Angel Velasquez, 3/15/1969.
Mr. Velasquez, you're charged with 6 crimes in this case. Counts 1, 2, and 3 are each a count of dealing in stolen property, trafficking. Each of those is a second-degree felony. Each of those is punishable up to 15 years in prison. Counts 4, 5, and 6 are each a count of receiving money from pawnbroker by false verification. Each of those is a third-degree felony. Each of those is punishable up to 5 years in prison. Do you understand the 6 crimes you're charged with, sir, and the maximum possible punishment you're facing?
Yes, sir.
Mr. Shields, how does he want to resolve these 6 charges?
Your Honor, he's gonna enter a plea of no contest to charge in count 1 and count 2. On both counts, he would be adjudicated guilty, be sentenced to 300 days in the Osceola County Jail with a credit for 176 days, time served, to pay court costs, cost of prosecution, a $250 regional conflict counsel lien. Restitution would be ordered reserved as the amount. And there would be, the remaining counts will be dismissed pursuant to the plea.
Who's the state?
Moreno Morales on behalf of the state, Your Honor.
Is this your agreement?
It is, Your Honor. The only clarification I would add is that there was no restitution requested from the victim.
Okay, that's fine.
Okay. Mr. Velasquez, is this how you want to resolve your case?
Yes, sir.
As you stand here today, are you under the influence of any drugs, alcohol, or other medication?
No, sir.
Have you ever been treated for a mental illness, emotional disturbance, or are you suffering from such at this time?
No, sir.
Do you read and understand the English language?
Yes, sir.
Your attorney has provided me a 4-page document. I'm going to hold it up. I don't expect you to read it from here, but it's called a plea form. It's got your name on it. It's got your case number on it, the 2 charges you're pleading to, the resolution, and all your rights. Did you go over such a form?
Yes.
Did you go over it with Mr. Shields?
Yes, sir.
Did he answer any questions you had about your rights?
Yes, sir.
Did you initial each paragraph indicating you understood it?
Yes, sir.
Did you sign on the last page?
Yes, sir.
Do you understand you're entering a plea today, which means we're not going to have a trial, and I'm going to sentence you this morning?
Yes, sir.
Has anyone forced, threatened, or coerced you to enter this plea?
No, sir.
Other than what's been discussed here in open court, has anyone made any other promises to you about the sentence you'd receive in this case?
No, sir.
And Your Honor, just very briefly, there are costs of investigation.
Yes, Your Honor. It's $2,090 to Kissimmee Police Department. I'll get the order.
We'd ask those be joint and several. You understand that? You're going to have to pay the $2,000 joint and several with your stepson. Okay? That's for the cost of investigation. I didn't have that beforehand, I'm sorry, but do you agree to that?
What was that?
There's $2,090
$2,090.
cost of investigation which would be joint and several with your stepson. It means he could pay it all, you could pay it all, doesn't matter, okay?
Okay, okay.
All right, all right.
Mr. Shields, in future, if y'all will just wait till I'm done with my
I'm
comment.
sorry, I just wanted to, I apologize.
Okay? I typically ask, is there anything else?
Okay.
And we can address those kinds of things at that point in time. All right, again, sir, has anyone forced, threatened, or coerced you to enter this plea today?
No, sir.
Other than what's been discussed here in court, including the cost of investigation that was just announced, has anyone made any other promises to you about the sentence you'd receive?
No, sir. I just wanted to have some time to pay that money. That's it.
We'll talk about that. Are you satisfied with the work Mr. Shields has done in handling your case?
Yes, sir.
Do you understand, sir, if you were not a citizen of the United States, entry of this plea would result in your deportation?
Yes, sir. I understand that.
Ms. Morales, factual basis for counts 1 and 2?
Yes, Your Honor. On October 14th of 2019 and on October 15th, 2019 respectively, at 1:20 p.m., the victim's residence captures an individual stealing some tools from their porch. And at 2 p.m., Mr. Velasquez is confirmed to have been pawning those items at La Familia Pawn Shop. On the October 15 incident, the individual is captured at 10:40, stealing the items from the front porch. And at 11 a.m., the defendant, Mr. Velasquez, is confirmed to have been pawning those items at Queen of Pawns Pawn Shop. Post Miranda, both defendants admitted to stealing the items. All these events occurred in Osceola County, Florida.
Any objection to that factual basis for purposes of the count 1 and count 2 plea?
No, Your Honor.
Sir, I'm going to accept your plea. I find you alert and intelligent. Your plea is freely and voluntarily entered. You understand the nature of the charges against you, and you're represented by competent counsel with whom you say you're satisfied. I also find a factual basis for the acceptance of the plea on counts 1 and 2. Is there any legal reason why a sentence should not now be imposed, Mr. Shields?
No, Your Honor.
All right, sir, the court having accepted your plea, I'll sentence you as follows. On counts 1 and 2 of the information, I'll adjudicate you guilty. On each count, I'm going to sentence you to 300 days in the Osceola County Jail. On each count, I'm going to give you credit for 176 days time served. The sentence on count 2 is concurrent with the sentence on count 1. I'm going to order that you pay all statutorily required fines, fees, and costs, along with the stipulated cost of investigation. What's that amount again, Ms. Morales?
$2,090 to the Kissimmee Police Department.
$2,090 to the Kissimmee Police Department. Madam Clerk, can you announce all of the other costs and then give me a total, including the cost of investigation?
$415 court costs, a $3 teen court fee, $100 cost of prosecution, $250 contract attorney lien, $2,090 cost of investigation for a total of $2,858.
The cost of investigation is going to be joint and several with any co-defendant who's convicted on this case. Sir, if I gave you 60 days from your date of release to get out of custody, get a roof over your head, start working again, any reason you can't pay $50 a month towards your cost?
No, it won't be no problem.
All right. I'll order within 60 days of your release from custody that you contact the clerk of the court, set up a payment plan, and begin making payments at a minimum rate of $50 a month towards your cost till your costs are paid in full. It's actually in your best interest to pay it off faster if you can, because every month you make a payment, a small portion of that payment is going to be an administrative cost that doesn't go towards your balance. Does that make sense?
Yes, sir.
All right. State, do you have an announcement on the remaining counts?
Yes, Your Honor, as to counts 3 through 6, state announces no process in exchange for the plea.
Mr. Shields, anything else?
No, Your Honor. Sorry about that.
All right. And Madam Clerk, anything else?
No, sir.
That's the judgment. And since the court in this matter, defendant is remanded to the Osceola County Jail to serve the balance of his sentence. Good luck to you, sir.
Thank you.
You're welcome.
Thank you. That's all I have, Judge. May I be excused?
You may.
Thank you, Judge. Good to see you.
All right. For the public defenders in the courtroom, I'd like to address any quick matters that we have in jail so that we can get those inmates on their way. If we have an extended matter that's going to require testimony or a long argument, we'll kind of hold that till we clear out the other numbers. So, Mr. Schmier, do you have any cases that fall in that?
Yes, I have an arraignment that was set for 8:45.
Okay. Tell me who that's in relation to.
Jose Menjivar Mejia, he's actually in jail. The clerk's office sent him notice outside. I just got a point a few days ago. He's actually in jail in the F-pod. So I filed a written plea of not guilty. The waiver of arraignment yesterday has not yet been processed.
Okay. Is this Mr. Minivar Mejia? All right. Sir, the Office of Public Defender has been
Excuse me,
appointed.
Judge.
Okay.
He apparently only speaks Spanish.
Okay. Osceola Jail, does he need an interpreter? All right, let me see if I have an interpreter available.
Good morning, Your Honor. This is Alan Figueroa, State Certified Spanish Court Interpreter.
Good morning, Mr. Figueroa. This is Judge Wooten down in Osceola County. I'm conducting an in-jail arraignment with a defendant who needs your services. Have you been sworn in yet?
Yes, Your Honor.
All right, let's go ahead and swear in the defendant.
Levante la mano derecha, por favor.
You do solemnly swear or affirm the testimony you're about to give in this case is the truth, the whole truth, and nothing but the truth so help you God?
Jura o promete que el testimonio que rendirá será la verdad, solo la verdad y nada más que la verdad. ¿Lo jura ante Dios? Yes, I do.
Timmy, do you have his jacket? Good morning, sir. Tell me your name and your date of birth.
Buenos días, señor. Dígame su nombre y fecha de nacimiento. I'm sorry, Your Honor. The interpreter was not able to get the whole name. I was able to understand Ramon Mejia.
Okay.
Señor, su fecha de nacimiento. March 15th of 1997.
Sir, you're currently charged with 2 crimes.
Señor, se le
Go ahead.
acusa de 2 cargos. Se le acusa de 2 cargos.
Count 1 is conspiracy to commit robbery with a deadly weapon, a second-degree felony, punishment up to 15 years in prison.
El primero es de conspirar para cometer robo con arma armada, lo cual es un delito segundo grado, sancionable con hasta 15 años de prisión.
Count 2 is attempted robbery with a firearm, a second-degree felony, punishment up to 15 years in prison.
El segundo es robo con a mano armada en grado tentativa, un delito segundo grado, sancionable con hasta 15 años de prisión.
Mr. Baird, what is the associated minimum mandatory on count 2? Sir, count 2 carries a 10-year minimum mandatory sentence for the actual possession of a firearm.
Señor, el segundo cargo acarrea una sanción mínima obligatoria de 10 años de prisión por la tenencia del arma. Your Honor, but I've never robbed anyone with a weapon. I work.
Sir, we're not here to try the case today. We're here for arraignment.
Señor, no estamos aquí en el juicio mismo, es solamente la vista incoatoria.
The public defender has been appointed to represent you.
Se le ha designado defensor público para que lo represente.
I'm sure your public defender would advise you to not discuss any of the facts about this case.
Y su defensor público le diría que no diga nada en este momento con respecto a su caso todavía. Okay.
Your public defender has announced that you're entering a plea of not guilty. Is that correct, Mr. Schmier?
That's correct.
Asentaremos declaración de inocente en este momento.
I'll enter a plea of not guilty as to each count. State, when does speedy trial expire? Assuming it wasn't told, when would it expire normally?
I believe that will be November 4th, 2020, if we were offered.
Okay.
After our, it will probably, this case will likely be
lowest case number is 301. So it'll likely be transferred there in the future, but I need to make sure that's going to be appropriate.
All right, here's what I'm going to do at this point in time. I'm going to set pretrial conference on this case for Wednesday, October 7th, 2020 at 9 a.m. Mr. Schmier, anything else I need to do at this point in time?
No.
Bien, lo que haremos entonces es fijar una vista preparatoria para el 7 de octubre del 2020 a las 9 de la mañana.
All right, that's the order of the court in regards to Mr. Velasquez, who will remain in the Osceola, not Mr. Velasquez, Mr. Mejia. If somehow.
Bien, esa es la orden que se emitirá en este momento para el caso del señor Mejía.
All right, that's the order of the court. And Mr. Figueroa, your case number is 20 CF 1339.
Thank you, Your Honor.
Okay. While we have you on the line, can you announce to my inmates and see if there's anyone else who needs your services this morning?
Sure thing, Your Honor. Si hay alguien más que necesite el intérprete de español, por favor, levante la mano.
Osceola Jail, do you have any other inmates indicating they need the Spanish interpreter? All right, thank you, Mr. Figueroa.
Not a problem, Your Honor.
So I'm sorry, the court never announced the trial date.
The pretrial conference is October 7th. The trial period would be October 19th.
Thank you.
Anything else, Mr. Schmier?
No, Your Honor.
All right, have a good day.
Thank you.
All right, so from the rest of the public defenders, do y'all have any cases that we can quickly address and get the inmates back to their regular location?
Yes, Your Honor. Good morning. Number 1 on the docket.
Is that Victoria, or Morgan Victoria Antosweski?
Yes, Your Honor.
Okay. All right, let's go ahead and swear the defendant in.
Raise your right hand, please. You do solemnly swear or affirm the testimony you're about to give in this case is the truth, the whole truth, and nothing but the truth, self you God?
Good morning, ma'am. Tell me your name and your date of birth. Ma'am, you're currently charged with 2 crimes. The first is possession of a controlled substance. That's a 3rd-degree felony, punishable to 5 years in prison. Count 2 is possession of drug paraphernalia, a 1st-degree misdemeanor, punishable to a year in the county jail. The Office of the Public Defender has been appointed to represent you. Mr. Carbone, what plea does she want to enter at this point in time?
I'd like to enter a plea of not guilty at this time, Your Honor.
All right. Who's the state on this case?
What's the case number, Your Honor?
Ms. Morales, question 1. Is there an offer for the defendant to consider at this time?
This one? Oh, no. That one.
Okay. What's the possibility that there might be an offer in the next hour if we hold on to the defendant?
Depends on how fast we get a rap sheet, Judge. That's the kind of hold up in the moment right now. I'm covering this for Mr. Peterson, so we can try to get somebody downstairs. I mean, we have limited staff to try to get us a rap sheet. Most likely tomorrow might be a better idea than today.
I don't know that anyone's going to be excited if I hold the defendant in the chapel at the jail until tomorrow, so I suspect that we're not going to get this resolved today. Can someone from the state tell me when speedy trial is going to expire on this case?
Speedy trial expires October 30th, Your Honor.
Assuming no tolling.
All
right. So here's what we'll do. We'll enter plea of not guilty at this point in time. I will set pretrial conference for Wednesday, September 2nd, with the trial period of Monday, September 14th. Mr. Carbone, if you get an offer that your client wants to take, then just get the case in here early, and we will take care of it early.
Absolutely, Your Honor. Thank you.
Okay, all right. Next. Okay.
Good morning, Your Honor. Alex Johnson on behalf of, let's see, the first case I have is Eric Moreno on page 1 of the docket, 20 CF 1094. Except for arraignment this morning, but I also submitted a motion to transfer. He has 2 case numbers out of Division 301.
Okay. Madam Clerk, do you have those?
I have the case numbers, yes.
Do we have dates that I can give right now in Division 301?
think that date is set yet, but let me double check. Because one of them he still has to be arraigned on. The 20 CF 844 he has to be arraigned on. Let me see.
Is there an arraignment date for that other
No,
case?
there was not an arraignment date set for that one. And on 20 CF 871, no. The dates have not been set. We do have the motion, well, actually the order as well, that was signed in March, but the dates haven't been scheduled yet.
Okay. Here's what, let's go ahead and swear him in.
Can you raise your hand, please?
Yes, ma'am.
You do solemnly swear or affirm the testimony you're about to give in this case is the truth, the whole truth, and nothing but the truth, self you God?
Yes, ma'am.
Morning, sir. Tell me your name and your date of birth.
Eric Christian Moreno, and March 3rd, 1993.
Mr. Moreno, you're currently charged in this case with 2 crimes. The first is aggravated battery on a pregnant person. That's a second-degree felony, punishable up to 15 years in prison. You can put your hand down, sir.
I'm sorry.
That's all right. Count 2 is false imprisonment. It's a third-degree felony, punishable up to 5 years in prison. The Office of the Public Defender has been appointed to represent you. Mr. Johnson, as to these 2 charges, what plea do you want to enter at this time?
It'd be a not guilty this morning.
Sir, I'm going to enter a plea of not guilty as to those 2 counts. Mr. Johnson, you've indicated the defendant has lower case numbers pending in Division 301. Is that correct?
Yes, Your Honor.
Does your office represent him on those 2 cases as well?
Yes, Your Honor.
Madam Clerk, if I accepted pleas of not guilty on those 2 other cases, would we have a Division 301 date we could give?
The next scheduled date for trial is going to be 7/29 and 8/3. Beyond that, let's see.
Mr. Johnson, any objection to entering pleas of not guilty on the other 2 cases? I'll sign the transfer order and I'll give all the cases the July 29th or the July date for.
The only reason I'd be concerned about that is just on the state side, it looks like an information hasn't been filed.
Okay.
On all the other cases yet, but I would be comfortable with it, but I understand.
Well, then that raises an interesting question.
Can we transfer?
Does the administrative order contemplate transferring cases that have not yet been to a division where there's not been a filing?
Actually, as of checking the benchmark this morning, I realized that as well. And I believe I may have filed this motion prematurely.
Okay, so here's what we're going to do. Sir, the state's not filed on your other 2 cases in Division 301, so it's not appropriate for me to transfer you at this time. So here's what I am going to do. I've entered a plea of not guilty on this case. I'm going to give you a pretrial date of, let's look at one more thing. State, when would speedy normally expire on Mr. Moreno's case?
You want? Oh, I'm sorry. Okay, sure. What's the case number?
The mayor.
Yeah, I'm pulling it up.
This is the first page.
Choosing harder than that. Let me get a calculator. Huh?
When was he arrested?
I don't know.
Sir, can I ask you a question about something else?
Hold on. The Office of the Public Defender has been appointed to represent you. Their advice would be ask them the question. They're likely to have the answer, or they're likely to tell you that's not a thing you want to discuss when prosecutors are listening and your words are being recorded, okay? So your public defender in this courtroom is Mr. Johnson. He'll stay on the case unless it gets transferred to another division, and then a different public defender will take over, okay? But Mr. Johnson's your source of answers at this point. That makes sense?
Yeah.
Okay.
Your Honor, it looks like it would be around November 27th.
Okay.
Assuming speedy.
I'm going to go ahead and set Mr. Moreno's case for pretrial conference on Wednesday, October 7th, 2020, and the trial period currently scheduled to start Monday, October 19th, 2020. Defendant will remain in the Osceola County Jail pending further order of the court. Case remains in this division pending a transfer being signed. All right. Mr. Johnson, if you can stand down for a second. Mr. Holland, are you ready to address your case?
Yes, Your Honor.
Remind me who your client is.
Curtis Bianchi.
I have a question, Your Honor.
All right. Mr. Moreno, again, you've got the Office of the Public Defender. There's a system out at the jail for you to communicate with them. Again, I just want to caution you, if you start asking questions now, you might say something that makes it difficult for them to defend you. So I know it may, in your mind, think it's no big deal, but I've seen cases fall apart for defendants because they said something they didn't think was a big deal. So talk to your public defender, okay?
I understand that, sir, but my public defender asked me to, it was a woman who I was with, and she asked if I can ask the state if I could plead guilty to my CT charge for my license.
Mr. Moreno, I will tell you that you have 3 public defenders on your case today. One of us will be contacting you today out at the jail, so that way we can better figure out how to coordinate these cases.
Okay.
So
All right, Mr. Moreno, you can step away. All right, I'm going to take care of an out-of-custody case. This is State of Florida versus Curtis Bianchi. Let's go ahead and swear him in.
You do solemnly swear or affirm the testimony you're about to give in this case is the truth, the whole truth, and nothing but the truth, so help you God.
Yes, ma'am.
Sir, tell me your name and your date of birth.
Curtis Armand Bianchi, 3/28/65.
All right, sir, you're charged with 2 crimes. The first is possession of heroin. The second is possession of drug paraphernalia. Your case is set for a drug court status today. Mr. Holland, what can you tell me about the progress of this case?
Well, this is the first time I've been in court to address this case. The only thing I got from the prosecutor was that they're going to recommend drug court. And I thought today was where he was signed up for it.
Who's the state?
Andrew Bancourt for Mr. Seville, Judge.
Okay. What's your knowledge of the progress of the case?
Progress of the case is this a drug court status day. I'm not sure why it was set for that. Because
Well-
Mr. DeVille wasn't the prosecutor at the time, so that was 2 prosecutors ago, so I'm not sure. But it looks that the case, the offer was a drug court referral. It looks like track 2 is the proper referral for that. I gave Mr. Collins the form this morning. You saw me sneaking by you to give him the form to make sure that's filled out. I think the proper thing to do at that point, if he wants to enter drug court, is to set it on Judge Whitehead's docket and give the referral to the clerks, and then have him report to Ms. Jones on the 3rd floor.
Okay. Mr. Holland, do you understand those are the things your client needs to do on his end to get in the program?
I'm just now learning that he got to go down to the 3rd floor to Ms. Jones and do necessary paperwork, then to be set on Judge Whitehead's docket for review.
Let me ask you this. Does your client want to waive his right to speedy trial in order to pursue the drug court program?
Yes, sir.
He's nodding his head yes. So here's what we're going to do. Listen carefully, Mr. Holland. I'm going to grant a motion to continue. In an abundance of caution, I'm going to set this case for a pretrial conference on October 6th and a trial period of October 19th, just in case something happens. But I'm also going to give it a status date in front of Judge Whitehead if the clerks happen to know what those dates are.
His next drug court status hearing is going to be July 17th and July 31st.
I will go ahead and set a drug court status date of July 17th, 2020 at 2 p.m. So, sir, you need to go down to the 3rd floor, speak to the program administrator. They're going to have you some paperwork to do, and you're going to need to be in court on July 17th at 2 p.m. to talk to Judge Whitehead about the program. If you don't do those things, you should expect that you're going to get kicked out of drug court, and you and Mr. Holland are going to be back here in October talking to me about a different way to resolve your case, all right?
Yes, sir.
All right, we'll go ahead and generate paperwork indicating the defendant must report today to Drug Court Administrator, Ms. Jones, on the third floor of the courthouse, and he must appear on July 17th for his drug court status unless there's further notice from the court changing his date, changing his time, whatever it might be. All right.
What was that trial date?
If he's back on my docket or he never gets off my docket, October 6th, October 19th.
Thank you. Wait for you.
Okay. Have a good day. He needs to stay for his paperwork. Mr. Holland, you're free to go.
I'm gonna wait for mine too, my copy.
Okay. All right.
Thank you.
All right, Mr. Johnson, anything else?
Yes, Your Honor, I have one other matter this morning. I'm with Michael Woods on page 3 of the docket. He's currently in custody.
Let's call it Michael Woods or Wood. And just for informational purposes, while they're getting that defendant, our 9 a.m. hearing on Jesus Moreno has been canceled. He has posted bond.
Thank you, Judge. May I be excused?
Ms. Cobb, was that all you were waiting on?
Yes, sir.
I'm sorry.
That's okay.
It's a pleasure seeing you.
Good seeing you.
All right, is this Michael Woods? I can't hear there we go.
Yes, this is Michael Woods.
All right, let's go ahead and swear him in.
Raise your right hand, please. You do solemnly swear or affirm the testimony you're about to give in this case is the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Tell me your name and your date of birth, sir.
Michael James Woods, 5/19/1984.
All right, we're here for a status hearing today. The Office of the Public Defender has been previously appointed. Mr. Johnson, what's the purpose of today's status hearing?
The purpose of today's status was to determine whether Mr. Woods would be able to get into the mental health court. We were here at PTC on late last month. Since then, we learned that mental health court would not be accepting him due to the nature of the charge in count 1.
Okay.
However, the state and I have been talking, and we believe we're going to be able to reach a negotiated resolution. We just haven't been able to get one done today.
Okay. Let me ask you this. How far out should I docket this case to give you enough time to reach resolution?
If I may just confer with the state briefly. Think we can get an offer? Yeah, that should be fine. Then we can say 1 or 2 weeks, and we should be able to get an offer and bring him back in.
Today is June 9th. I could put it on a pretrial docket of June 24th.
That would work, and if we can negotiate something sooner, would I be allowed to set him for an earlier plea date?
Okay. All right, Mr. Woods, here's what we're going to do. I'm going to give you a pretrial date of June 24th and a trial period that starts July 6th. That's just for control purposes. Your lawyer is going to be talking to the state attorney's office, and he anticipates that he'll going to be able to tell you a plea offer for you to consider. If you decide to take the offer, we'll get you in and get your case resolved. If you're uncomfortable taking the offer, then on June 24th, we'll talk about what needs to be done to get your case ready for trial. Okay?
Okay, thank you.
All right, you're welcome. Mr. Woods will remain in the Osceola County Jail pending disposition of his case.
Thank you, Your Honor.
All right. That's it, Mr. Johnson?
That's all I have this morning.
Okay. All right, Osceola Jail, do you have any inmates left that you are expecting me to talk to?
We still have Wilkins on the paper.
All right, and I see that now. Mr. Carbone, do you represent Mr. Wilkins?
Yes, Your Honor. Donald Carbone on behalf of Mr. Edwin Wilkins in 20 CF 441. Your Honor, this is set for a plea. However, Assistant State Attorney Dan and I are discussing certain prerequisites.
It's kind of a legal issue, Judge, that kind of came up at the last minute, so I'm trying to clarify the statute and get to a proper resolution in this case that's legal.
Do you feel like, I didn't catch the very last part, do you feel like we're going to reach that answer this morning?
Yes, Judge. Essentially what's going on, Mr. Wilkins has never had a license. The case law says that he's never had that if you've never had a license, you can't be convicted, driver's license suspended. There were some changes in October of 2019 to the statute. I'm talking with the prosecutor that filed this case, and apparently he's made some notes that thinks that he can be convicted based on the new changes. I'm reading the plain language of the statute, and I'm kind of struggling with that idea. So I'm trying to get some clarification as to what's their theory that he can be convicted for a driver's license suspended if he's never had a license, even as a habitual traffic offender. Because this prerequisite is that you at some point were issued your license to drive in the state of Florida, under these circumstances. So I looked at his driving record. He's never had a Class E or a Class A license. So
that's interesting because it's been a while since I've looked at this issue, but
yeah.
My reaction is traditionally we've talked about someone's privilege to drive
Right.
being suspended.
Correct.
And I thought there's a lot of case law that says you in fact can be convicted even if you never obtained a license if the privilege has been suspended. But I don't have a case directly in front of me that refreshes my recollection on that point.
When you were working in our office, that was the case law and that was the law. Subsequently, around 2016 or so, 2016, 2017, there are cases that started going up to the DCAs. But it took a while for to get a county court case that high. Usually they're on felony traffic or license suspended cases. And the DCA, in their plain language, their reading of the statute said that it clearly says you had to have a license to drive. So they didn't cancel this. So I'm trying to.
I have a case
I'm trying to see what this changes.
All right. Doesn't seem very fair that they're going to change the law on me after I get on the bench. But all right. So, Mr. Wilkins, here's the situation. There's a legal issue about what the appropriate charge is, and the prosecutor's trying to get to the bottom of what they think the appropriate charge is. Your lawyer's also trying to get to the bottom of the appropriate charge. That could affect what the resolution is. So I understand that you thought you were coming into plea today, but I think both the state and the public defender have an ethical obligation to not let you plead to something that's an unlawful charge. So they're trying to get to the bottom of that. They're hopeful they're going to be able to do it this morning. So I'm just going to ask that you be patient, and we'll hold you here in the chapel at the jail. Hopefully we'll get an answer and you can resolve your case today, okay?
Yes, sir, thank you.
All right, you're welcome. You can sit back down.
Interesting. Well, just to be kind of while we're on the subject, Judge, it looks that in 3.22.34, subsection 2, the legislature added the language as provided. So this says the license or driving privilege.
Okay.
They may have in their negotiations revamped that. So it may be possible to then at that point.
And what's the effective date of that statute?
That's October of October, I think, the 1st of 2019.
Okay.
I think, and this offense happened February of this year.
Okay. Mr. Carbone, you want to take a few minutes and look at the statute? If y'all are comfortable that the legislative change has addressed whatever concerns that the DCA's had, then I'm comfortable going forward with the resolution. If for some reason you feel like you need some more time to do some research, I'm fine with that as well. I think ultimately Mr. Wilkins probably is the person who's most interested in whether this is going to resolve today or not. But if both sides are comfortable, I'll go forward, as charged. If y'all need more time, then I'll give y'all more time.
How about you just have
Okay.
2 minutes?
All right. So while we're waiting on Mr. Wilkins' case, Mr. Morrison, I see that you've got matters later this morning.
Oh, which just matter or not matters?
Well, I'm showing Kwok Kondok Lee,
Yes, Your Honor.
but I'm also showing Marie Castelli. Status on burglary of dwelling and a VOP.
Yes, Judge, for the trial status, essentially.
Okay.
That one I can address now, Judge. Mr. Lee is still being held up downstairs at the checkpoint.
Okay. All right, so Ms. Morales, are you the prosecutor?
Yes, Your Honor.
All right, so let's go ahead and address Marie Castelli. She's on our 11 a.m. docket, but everyone's ready to talk about it now. So, Mr. Morrison, where does Ms. Castelli stand in preparing her case for trial or alternative?
We are prepared for trial, Judge.
Okay.
State's mostly ready for trial. I have a couple phone calls left on the defense witness list, but I don't expect that won't change.
Okay.
I can provide numbers if the ones you have don't work.
Okay.
Okay, yeah. There's just one I can't contact.
And State, remind me just in a few sentences what the kind of the story of the case is.
Sure. Ms. Caselli is on probation in case 2018 CF 3390. It's an aggravated assault case. That probation is alleged to have been violated with the new law case, which is 20 CF 93. Essentially, the victim has a parrot in her house, and Ms. Castelli goes in, gets the parrot out, and then the parrot ends up getting found.
Okay.
And is released in the deputy's car by accident and flies around a while, but things happen.
Well, jurors won't be able to complain that the case is boring.
It's not.
Okay. So what kind of offers have been made to resolve the case?
Ms. Caselli scores DOC, and I think my last offer was bottom of the guidelines if I don't.
I believe 56 months or something along those lines.
Something.
Well, I assume part two of her problem is, given the nature of her violation, she's a violent felony offender of special concern.
She is.
Okay.
And the court had at pretrial agreed to hear the factual matters and then set anything else for a later date.
Right. Okay.
I think it's 36, not 56.
Okay.
But I know that's not really much of a difference for her.
State, and Mr. Morrison, I don't want to preclude you from offering anything for my consideration, but by the same token, I don't feel it's appropriate to compel you to tell me the theory of defense, at this point. So, question for Ms. Morales. Was there any sense from the state's evidence that there was a prior relationship between the identified victim and the defendant? The defendant used to live there?
No.
Is there some dispute about the legal ownership of the parrot?
No.
Just
I can fill in from defense's point of view what happened if the court would be willing to hear it.
sure.
The parrot was stolen by one of the state witnesses, Your Honor, sold to a defense witness after my client's husband killed the same bird, of the same sort. So the client's husband bought this one, replaced it with the now stolen bird. My client was unaware of that change, Judge, and she couldn't inform the officers of that. However, my client's husband's testimony, as well as the testimony of multiple witnesses who saw parts of that transaction, would testify that, yes, she did possess the stolen bird without her knowledge that it was the stolen bird, believing it was her legally owned bird. As you said, Judge, it won't be uninteresting.
Right. State, what's the, in regards to the burglary, did the identified defendant have some form of access to the residence where the parrot was living, for lack of a better term?
Yeah, I mean, they broke in. They broke in.
Okay, so this, from that point of view, from the state's evidence, this is a garden variety burglary. There's some type of forced entry, and then this particular property is the property that's removed.
Right.
Okay, all right. Well,
If only the bird could testify, that'd be great. But
it may very well be. Well, Mr. Morrison, this may just be one of those cases you have to try.
Yes, sir.
Because I am guessing that the complicating factor is the violation of probation.
It's
Maybe
one of
not.
the complicating factors.
So, all right. My understanding is that we're now not summoning jurors until mid-July. So probably what I would like to do is bring her back at some point early July for trial management, for lack of a better term, to figure out where this case is going to fall in relation to, because at this point now, I have a 1-week trial period in the month of July. Assuming that I can actually get jurors in on July 20th, assuming there's no other change, I'd have 1 week to try whatever cases are going to get set for trial. And I don't know at this point that there are going to be any additional resources to assist the criminal court in working through the backlog of trials that we potentially are going to be facing. So if we get additional resources, then obviously that makes things slightly easier, but then we actually have to pick jurors in this environment, which is going to probably be, I'm not sure anybody's fully come to grips with what jury selection is going to be like when we start asking people questions, assuming we start asking them on July 20th. So
Court's expectation that July 20th date will hold, Your Honor?
expectation. It's my expectation. My expectation is that it's not necessarily going to hold. In no way am I trying to find flaw with what the Supreme Court's ordered, nor all the hard work that the statewide work group that Judge Bunyan is kind of leading the charge on. They've done tremendous work in coming up with some recommendations for best practices and thoughts on how to proceed and metrics. This just is going to I think the Supreme Court's going to have to consider several factors. Number one, are we logistically ready to conduct jury selection in this new environment? And then question two, is it prudent to try to conduct jury selection? And how confident are we that we're going to get jurors who can focus on the evidence, follow their oath, and not be distracted or concerned about extraneous matters? So it wouldn't stun me if we get to the end of June and the Supreme Court says we need some more time. This is a large courtroom, but you can already notice how we're supposed to seat people. So
Those numbers might work for county court.
Yeah.
So if I follow that guidance, I could get probably 20 jurors in here. So if y'all want to just get rid of peremptory challenges and live in a world, without making too much light of the situation, I don't know whether there's going to be defendants who are going to say, you know what, I'd rather try my case even though I don't get the robust jury selection I might have had in other circumstances. There may be defendants that feel that way. I don't know what the state's position is going to be. I think philosophically, both the state and the defense are philosophically entitled to a venire that can fairly hear the issues and decide the case. So, there's that famous, quote from Donald Rumsfeld when he was Secretary of Defense, where he talked about, the known unknowns versus unknown unknowns. The things we don't know that we don't know. And I think there's a lot of things we don't know that we're going to have to work through. So, on some level, I'm happy that I don't have to make those philosophic jurisprudential questions. I just have to implement what they tell me. So, I will suggest that if you're going to tell me the choices are to shove your docket forward versus make sure the process is fair, I'm going to fall on the side of process fair every time. And, the docket numbers are the docket numbers. We'll deal with them the way we can. So that's probably a longer answer on expectation than you were hoping for, but that's what you got.
I appreciate the court's insight, Judge. Thank you.
All right. I suspect that this may be your other client who's arrived. I could be wrong.
Is Mr. Lee, Judge? Yes, I just have to go over one term with the state judge, and we.
Whenever you're ready, let me know. We'll recall your case.
Yes, Judge.
Mr. Bain, apparently Ms. Jones is not holding office right now down on the third floor.
I don't know, Judge. I spoke to her about 3 weeks ago now, and they said that they're still kind of limitedly operating, but operating. I can send her an email and.
Okay, why don't you send her an email, see if there's some magic.
Yeah, see if there's
Maybe
some-
she's in her office and you have to knock the secret knock to get in, or.
The double doors? Is that That's it? Double doors aren't open on the third floor?
All right, I'm gonna take about a 5-minute recess, let the lawyers clean up whatever they need to clean up. We'll get back in and we will close out court.
You might bring that Morgan chick back. She said she was technically gonna count 2 first time served, but then she's done 1 out of 7 all.
No, I don't have, yeah, I'm gonna send her an email.
It's family court services. Oh, okay. It should, yeah.
It's the chapel. I have the whole code.
Yes, ma'am.
That would have been too much like right.
Dude, I usually calling somebody.
I bet you she'd run back here.
He just needs to call, it's Mrs. Jones. So me and Mrs. Jones.
46 days?
I think promise is that one thing I added, and I forgot to ask about this, probation when he gets out to run current. He's on probation right now, not violation. Looks like this to run current. That way he actually starts this when he gets out, not as the finish.
Who, which one is that?
This is also it could be concurrent, it's not coterminous, I guess.
No, not coterminous. Like, we couldn't do. The only way we can do coterminous is this shit. So,
See if, yeah, I can dial through this to see if the,
I've never seen it done. But I'd like to have it done.
I think the better idea would be that he be on,
Are you guys coming back tomorrow? Yeah. Because I don't know what.
yeah, the probation wouldn't start on counts
Because I start tomorrow, so if you guys.
She was time count two. Yeah, she was time serving on this and that.
Well, you can't count zero.
DOC and on that.
Because today I was just gonna finish on my intake.
Yeah, so it's the jail, because you usually the jail count one.
Yeah, sure.
Yes.
So,
Followed by
I guess Steven just license suspension from
figure out.
current.
yeah,
Is it 2 years? No, 1 year.
I feel like, so this is probably one of yours, it's just not
So I can get a copy of this from Beth.
I'll make, I can make a copy of it, because I need to figure out, like, right now, this has Peterson, and then Bader.
I mean, that's like everything. Like, they make us write on these.
And then we're splitting the blue dots.
So what actually needs to happen is that
Like
needs
all my stuff I
to
sent
be,
type of all forms and everything. Like, it's like
You gotta come work with me. Then
They're
it's required.
oh, they are?
Remember, I had that hearing on this.
Oh.
Totally. I'm like, oh, right, yeah.
so we gotta
I mean, it's written down somewhere. It's just, you know, I don't remember about what.
so that's the,
Glad the judge mentioned that before it left.
How's it working at the bar?
What's that?
What you doing at the bar?
Oh, taking licenses away and like bringing down the family around people, man. It's impressive. She's like a little prosecutor.
It bumps all the time. Is that what's going on? For whatever reason.
That's the one that has the rainbow colored hair.
Okay, I've never, I've only, people have ever heard of it.
Actually, one out of your office.
I think I've never.
Usually been on people or something. So, it's like, they get on that side of the, thing on that.
Different.
Well, some of them are technically.
No, I don't think anybody has talked to her since she left.
Arrangements purchase sex.
Oh, Andy.
Interesting.
Yep, you're right. Yeah,
we'll do Microsoft Teams.
you're right, because I don't know anything about dependency.
I didn't take them on that case.
Because when I worked over there and helped them out, I worked over there for like 6 months, but I did strictly juvenile.
Set it off. I have to set it off 10 weeks. So that can-
Yeah,
Probably do though, I think it's
right.
For sure. I judged the case and I was like, well, it's leaning this way.
I don't know. I mean, I've seen Kelly here, 8, 9 o'clock every night, and I'm like, nah.
Which I guess isn't the thing.
like, we'll cover
Yeah, we
whatever.
don't have the restraints, but there's a commentary on the situation.
I don't know where you're gonna
Mine
find
gives you the info. I appreciate it.
Share just
Okay, so what else is on
already.
It's good.
I guess I'm gonna take on my desk if you want.
Oh my gosh. We'll do whatever. Just, I haven't been back to the room in a really long time, so.
Really?
Yeah.
Oh, okay.
Yeah. Only I have some non-arrest stuff I still have at home.
Yeah. Yeah, somebody that really wants to do
I
it.
took one step.
Dedicate the time to.
To your home. At the same time, I also got like a stack this big on my own. So
I know, right?
I ordered lately because it seems that like you got a book, you got arrested.
Who?
And it's like some weeks.
Oh, really?
Yeah, all of a sudden I walk in my office and like 15 gets
Yeah.
Right. I don't remember him, rather.
So, I was talking to Maria, she had to work every day this week. What time does he start?
Exactly.
This one doesn't.
Oh, really? Who is there now? Oh, okay.
We have Friday?
We have a Friday docket.
Okay.
Maybe
Yeah, it's like this.
or one of
There's not much of it, it just takes a long time.
Would you be okay with me getting my bearings this week and then next week just jump into whatever
Yeah.
case, I don't know, whatever the case
I
is?
mean,
I don't know.
the thing is, I mean, the thing for Ms. Peterson is not his last day today too, it's tomorrow.
No, I couldn't do that.
Right.
Huh?
I don't know what these are. So
I can only imagine, honey.
like they just
I can, yeah, I can only imagine. I couldn't sit and listen to that.
supposed to be in March.
Mm-mm.
So we have to pull in these guys.
I could not.
Oh, this is from last week. So we just. No, progress for it. I think they do.
I know Kelly and Sandy been doing it for a long time.
They've been there a long time.
Go for PTC. And ours is Thursday.
Kennedy was in the chair.
Mm-hmm. Mm-hmm.
You know how the PTC is next week, you know?
Oh, Thursday.
What, for April?
For
Is the April reset?
it's part of the it's part of that.
Okay.
Not all of it though. But it's part of it.
I'm just saying, the only thing I can see is April, and the next PTC day is April, the 3rd, June 3rd.
She's back.
I've also just never
Yeah, she's back. She came back Monday.
learning how to do these things. I never went to Blue Dot. I went straight to county and
She
juvie.
has her mask, of course. She has her shield on. I call it her motorcycle helmet.
Years.
I tell you.
It's gonna be years.
But yeah, she came back Monday.
Okay.
Today.
She's so funny. Yeah.
I had a good teacher.
There's a manual.
He's a male, but some of it is not.
Oh. Well,
Some of it's not right.
Well, I mean, I'm talking about the one for the phone, correct?
Yeah, that's it.
Which, as it turns out, is pretty regular.
Just a message. And give I'll probably give his number too, I would say.
Yeah, I'm just gonna wait till I hear back from her, and then I'll tell my client.
Oh, he took. I think he took.
All right, guys, so
All right.
There was a hot one.
stay safe, okay?
You too. Thank you.
You try to send me this email.
Kelly. Yeah, well, it's gonna plead, but I think they're gonna bring back, the girl back working in TTC. I think they're trying to bring her back. Look, I don't know what happened with that. I gotta ask the judge.
Peterson and Alana. It's gonna be fun. Yes. So I did juvie, one did juvie, and then intake. Juvie was fun. No part of the trial ever.
At least it's in here.
I mean, well, they've maxed probation and essays, but nobody gets to go to kid jail. Yeah, they don't, it's just like, you have to be a really bad kid to go to kid jail. Huh? I don't know. And I really enjoyed working with
Because you had it written down?
I haven't been there, I said, let me just sit here and read.
Really enjoyed it. She was really sweet.
Oh, really?
I'm just kind of like, because I don't technically start till tomorrow, but then I'm here because I wanted to figure out what's going on. And with intake, I'm dropping off all my cases, letting the next person kind of, like, absorb, take in whatever.
He almost said it.
Uh,
No, I said he almost said it, bro. And you know what? The judge said, let's try this again. And walked out and came back in and had him announce it again. This was yesterday.
They do like Springfield County.
Yeah. I don't know what he was thinking.
I'm having,
Yeah.
like, I'm with you, like,
I don't know where Burke's
then
mom was.
they want us to go up to where, I don't know, man. It doesn't, I want to ask somebody, like, where do they, I understand, I guess, the face mask.
I've just been thinking about, you know,
Basically, we can get this
Motions to suppress their motions.
You don't really.
thinking about Biggie. Is there anything about him or something?
I don't know. See? I gotta get prize and I gotta get back in the courtroom.
Yeah. He's good. No. I think if you're both masked.
Okay.
The first thing is always do is mask and mask. Yeah.
No,
It's always like, it's just,
bring some popcorn.
Understand your reasoning.
I'm trying to figure out, like,
Entertaining for sure.
Because he does the
there's
challenging.
just so many problems.
And I'm like,
Come on, man.
this is my first one. I mean,
You don't have glasses.
I think they
and I like this little paper. It's like, are you saying that this? And I'm
CDC
like,
thing is like if you're
I
both
mean, I might be, I don't know.
the chance that you get in the virus like 5%.
It's gonna be fun, guys.
So yeah,
I'm excited to get back in here.
No, I'm just curious to know what they, like, what the intention is.
Like quarantine and then, like a.
I'm sure it's good, I just don't know if that.
It makes sense together. It's weird that the year's almost over.
I appreciate that.
there's there's elbows.
Because I keep looking at everything.
See a lot of chiefs. Probably our administration, a lot of chiefs. Too many. So
That's why I like PCC coming
it
up.
does layer of.
Whatever the other was last time.
That's good.
We shall see. What's up?
I'm just like,
Can we help you?
be like, take these cases along and like, drop them off to the
I sent you an email. That's
No, that's not. That's not my emails out.
That's the one
People are just kind of like, oh,
Were you able to get it though?
it doesn't exist anymore.
Exactly, yep. And then I have the opposite
No?
with some cases.
Oh my God.
It went
I
through.
called you like every month before, now I'm gonna call you every day. Multiple times. Yeah.
That was one of the tough things.
Well, that's when you get the speed limit.
Because, you know, at that point you're getting. the
Or
case
actually, I'm doing speed limit when you.
Not a lot of them, but the ones
Or at
where
least
I'm like,
I would.
I'm not gonna be able to prove this. I'm not even gonna move forward. This isn't great. Having to talk to the victim and be like, it's not good, guys. Like, what?
Yeah.
What do you mean? I'm like, yeah.
So,
The burglaries of conveyance.
well, possibly he left.
Because you know how Leo's kind of attached like 20 of them to one kid or one person.
Yes.
And they're like, hey, we all did these.
As far as I know, there's only one person who didn't come back. Having some babysitter.
And having to reach out to those victims. they're like, what do you
She
mean?
may be out
What did they do to him? And
the
I'm
rest of the
like,
summer from what I'm told. I don't know.
Well, I gotta reach out to you.
Because he was almost
How you been otherwise? You good?
And then they just sent out 3 emails for new positions that are opening up
that's how I work like doctors.
within the clerk's office.
trying to, you know, do the whole settle down and regain stability.
Well,
Yeah, I don't know, it's good.
This board is back in session.
All right, thank you. Everybody seated. All right, Mr. Morrison, are you ready to call up Mr. Lee's case?
Yes, ma'am.
Okay.
Good morning, Judge.
Good morning. Let's go ahead and swear Mr. Lee in.
You do solemnly swear or affirm the testimony you're about to give in this case is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you can put your hand down, sir. Sir, in a nice loud voice, can you tell me your name and your date of birth?
My name is Kwok Kan Lee. Day of birth July 20, 1975, sir.
Okay. Sir, in this case, you're charged with 3 crimes. The first is fleeing or attempting to elude a law enforcement officer at high speed or with wanton disregard. The second is driving under the influence, a misdemeanor of the 2nd degree. That first charge is a 2nd-degree felony, punishable up to 15 years in prison. Count 2 is driving under the influence, a 2nd-degree misdemeanor, punishable up to 60 days in the county jail. And count 3 is just resisting officer without violence, a 1st-degree misdemeanor, punishable up to a year in the county jail. Do you understand those 3 crimes, sir?
Yes, sir.
Do you understand the maximum possible punishment you're facing?
Yes, Judge.
Mr. Morrison, how does he want to resolve his case today?
We're entering pleas of guilty to all 3 counts, Your Honor, and asking that sentence be set off 10 weeks until, which I think would be week of August 24th. But as to count 1, Judge, it would be 8 months in the county jail with whatever associated driving license suspension the court chooses to impose. Count 2, Judge, would be probation consecutive to count 1 and would be standard first-time DUI minimum sentencing, Your Honor. And the 3rd charge, Judge, would just be an adjudication of guilt. And, of course, all associated court fines and costs. And probation would run concurrent to a probation that he's on right now. This would not violate his probation, though, Judge.
Okay. Who's the state?
Andrew Bain from the state, Your Honor.
Mr. Bain, is this your agreement?
Yes, Judge, it was Ms. Ramos' agreement, and I'm just honoring it, Your Honor.
Okay. And Mr. Bain, you provided a case the other day that stands for the proposition that the court is not required to immediately impose sentence upon a plea for a DUI. Is that your reading of the statute and the case law?
The case is interesting, Judge. The Kramer case I provided to the court, they had commentary on the issue without actually making a decision, but they kind of left it with the idea that a proper sentencing hearing is something that the defendant's entitled to, but kind of left it for a question that may be answered on a later date by the Florida Supreme Court. So right now, I think it's appropriate. I do agree with that idea. I think that you can't, in their interpretations of what the reading is, give a withhold adjudication or suspended sentences and those kind of things, but I think a proper sentencing hearing is something that defendants should be entitled to.
Okay.
Or it said either way, either reading is potentially a correct reading, Judge, so it gives some intellectual backing to the idea.
Yeah.
All right, then based on the state's agreement and my reading of the logic of that case, I'm going to retreat from my previously held position that I'm required to impose sentence immediately upon the entry of the plea. Now, Mr. Morrison, have you had a discussion with your client about entering a plea today, coming back on a future date, and the potential ramifications if he were either to not come back or if there was probable cause to believe he committed another crime while he was pending sentencing on this?
Yes, Judge, I've informed him that should any of those circumstances, occur, his plea would stand, but the court would not be bound by the negotiated agreement it's agreed to accept, and so you'd be facing the maximum.
Okay. And Mr. Lee, you understand that?
Yes, sir.
And have you decided that it's in your best interest to enter the plea today and come back on a future sentencing date?
Yes, sir.
As you stand here today, are you under the influence of any drugs, alcohol, or other medication?
No, sir.
Okay. Let's move you a little bit closer to the middle of that lectern. There's a microphone there. You're a little soft-spoken, and the mask could make it more difficult for our court reporter to hear you. Have you ever been treated for a mental illness, emotional disturbance? Are you suffering from such at this time?
No, sir.
Do you read and understand the English language?
Most, sir.
Okay. So your attorney has given me a document called a plea form. I'm holding it up. It's a 4-page document. It's got your name on it, your case number on it, the charges you're pleading to, the resolution, all your rights. Did you go over this form with Mr. Morrison?
Yes, sir.
Did he explain to you all the rights you have and the rights you're giving up by entering this plea?
Yes, sir.
Did you understand everything he explained to you?
Yes, sir.
Did you have an opportunity to ask questions about anything that was not clear?
Yes, sir.
And did he answer whatever questions you might have had?
Yes.
Can you speak up?
Yes, sir.
Did you then initial each paragraph indicating that you had read it and you understood it?
Yes, sir.
Did you sign the last page?
Yes, sir, I did.
Do you understand your entry to plea today, which means we will not have a trial in your case, and I will set you for sentencing on a future date?
I understand, sir.
Do you understand, sir? If you don't come back for your future sentencing date, your plea will stand, but I will impose whatever lawful sentence I think's appropriate, and that might include whatever facts come up about why you didn't come back, and it may not be the sentence negotiated by your attorney. You
I do
understand?
understand, sir.
Do you understand that if I'm made aware and presented with probable cause to believe you committed any crime while you were awaiting sentencing, your plea will stand, but I won't necessarily be bound by the negotiated resolution. So the real question is, do you trust yourself to come back for your sentencing date and to follow the law and avoid any future problems while you're out pending sentencing?
Yes, sir. 100%, sir.
Huh. Other than what's been, has anyone forced, threatened, or coerced you to enter this plea?
Absolutely no, sir.
Other than what's been discussed in this courtroom, has anyone made any other promises to you about the sentence you'd receive?
No.
Are you satisfied with the work Mr. Morrison's done in handling your case?
Yes, sir.
It looks like he's done a good job for you, sir. Do you understand, sir, if you were not a citizen of the United States, entry of this plea would result in your deportation?
Yes, sir. I understand.
Mr. Bain, factual basis for each of the three charges?
Your Honor, on November 1st of 2019, law enforcement received information about a reckless driver. Law enforcement was able to find the defendant who fit the description from the call. The car was being driven at a high rate of speed and then began to slow down and then speed up. Law enforcement attempted to make a stop of the vehicle, but using his lights and sirens, the defendant refused to stop. Law enforcement drove directly next to the defendant, made eye contact with the Leo. The Leo drove in front of the defendant, who at that point was driving very slowly, and was able to use a pit technique to get the vehicle to stop. The defendant refused to get out of the car. Law enforcement observed the defendant attempt to light a crack pipe that was found inside of his hand. Subsequent to the stop, the law enforcement ended up having to break the windows on both windows and pull the defendant out of the car, and he was arrested. And all these things happened in Osceola County, Florida.
Any objection to that factual basis for purposes of the plea, Mr. Morrison?
None for the purpose of the plea, Judge.
Sir, I'm going to accept your plea. I find you alert and intelligent. Your plea is freely and voluntarily entered. You understand the nature of the charges against you, and you're represented by competent counsel with whom you say you're satisfied. I also find a factual basis for the acceptance of the plea based on the presentation here in court and the affidavits filed in this case. Other than the fact that we are setting a sentencing date, Mr. Morrison, is there any legal reason the court could not impose a sentence?
No, Judge.
All right. So, Mr. Morrison, what are your thoughts about when I should docket this for sentencing?
Our request, Judge, would be the week of the 24th in August, and we believe that gives Mr. Lee enough time to complete his drug treatment down in South Florida.
How about if I set it for Monday, August 31st, 2020?
And I apologize, Judge, that was the day I had Judge. We have my calendars. We have no objection, Judge, yes.
All right. And would Mr. Lee be traveling up from South Florida?
Yeah, in trouble.
Would it be helpful if I set it later in the morning, say 11, as opposed to
11.
8:45?
Indicates that yes, Judge, that would be
Yes,
helpful.
sir.
Here's what I'll do, sir. The court having accepted your plea, I'm going to set you for sentencing on Monday, August 31st, 2020 at 11 a.m. in this courtroom. You must be present at the time of sentencing. Do you understand?
I understand.
I'll also order as a condition of your plea that you commit no new criminal offenses while you are out pending sentencing. Do you understand, sir?
Yes. sir.
All right. Some free advice, sir. If something happens, the number one thing you should be doing is contacting Mr. Morrison to make him aware of the situation. The worst thing that you could do is not be here on August 31st and have Mr. Morrison standing here saying, Judge, I don't know. He's not answering his phone. He's not responding to email. I don't know where he is. Because I've had that happen to people, and they just made the situation worse for themselves by just, well, I assumed I was in trouble, so I just ignored the situation, pretended like it was going to go away. That didn't help their cause. Okay?
Yes, sir.
State, anything else?
No, Your Honor.
Mr. Morrison, anything else?
No, Your Honor.
Sir, I'm going to order that you step over to be fingerprinted. I'll order that you sit down and sign for your paperwork, reflecting that you know you're supposed to be back on August 31st. Madam Clerk, anything else?
No, sir.
Okay.
Thank you, Judge.
You're welcome. State, I'm going to return your score sheet for you and your sentencing paperwork. Mr. Morrison, before you leave, the one thing that I never did in all of our rumination about Ms. Costelli's case is actually give you a date to come back to court.
Oh, yes, Judge.
So,
We discussed something you said, Judge, in early July.
so there are essentially two ways I can do this. I could just put you on the June 23rd pretrial with the expectation that on June 23rd, I would be setting you for some type of trial management conference somewhere maybe the week before July 20th. Or I could just guess and give you a date now in July and not bring you to pretrial. The only risk is I may end up having to move that date again. So whichever way you want to do it,
I can avoid a pretrial, Judge. I always make steps to do that.
Okay. So here's what we'll do. On Ms. Costelli's case, I'm going to place her new case on the June 23rd pretrial conference. Mr. Morrison, I'm intending to do that through Microsoft Teams. If you want to avail yourself of that, if you feel like you need to be in the courtroom, you're welcome to come to the courtroom. You should be getting an email from my JA shortly before the pretrial, basically telling you which option you want to take so that she knows whether to invite you to the virtual or not.
Oh, Judge, when the court had inquired, Judge, I was saying if I could avoid a pretrial, that would be.
Oh,
I was
okay.
asking the court if it could select a date. I'm sorry, I wasn't
I misunderstood.
clear about that.
Let's do this. I will set a trial management on Ms. Costelli's new case and her VIP for July 15th.
Excuse me, we have Ms. Costelli here at the jail, so she can hear everything I'm saying.
Okay, that's fine. Her attorney's here in the courtroom. We're just talking about scheduling. Thank you. All right, Ms. Costelli's trial management conference is going to be July 15th actually, let me change that. Let's make it July 14th. At 9:15 a.m. My expectation on July 14th, assuming that we're going to have access to jurors on July 20th, is everybody needs to know all the answers on their witness issues, how many days it's going to take to try. I put it on July 14th because that's a day I have access to inmates. I would anticipate whatever the state's offer being placed on the record. Ms. Costelli can then either take the state's offer or decline the state's offer. The one thing I want to caution her about, since she's listening, it's trying cases is going to be much more challenging logistically, and we're going to have much higher demands on jurors and much more limited ability to get jurors here. So setting a case for trial is going to be far more significant than maybe it has been in the past. So what Ms. Castelli needs to consider is if she announces trial at trial management, I will do everything in my power to find a judge, a courtroom, and a jury to try her case. What I won't do if she announces trial is accept negotiated resolutions after that point. And that cuts both ways. State, decide what your case is worth, make the best offer to resolve it, but be prepared that you're stuck trying your case. The state always has the power to null pros, but would not be inclined to be resolving lots of cases on the day of trial the way it has been done oftentimes in the past. Any reaction to that, Mr. Morrison?
None, Judge.
Okay. All right, that's the date for Ms. Castelli. She can remain in the Osceola County Jail pending disposition of her case.
Actually, I did have one inquiry, Judge. On that trial management conference, where would the court like me to be physically?
The jail would probably prefer that you're not in the jail. I'm sure their preference would be the fewer people in and out, the better. So courtroom will be fine. If there's a decision to accept a plea on July 14th, I'm not going to derail the process because there's not a plea form. What I would anticipate doing is then just taking her off the trial docket, letting you get the paperwork done, and taking the negotiated plea.
Yes, Your Honor.
Okay. So, my only goal here is to only set cases for trial where there's truly irreconcilable differences between the state and defense that a jury has to sort out. And that's fine. We'll do the best we can to try those cases. You know, all the other cases where maybe people are just hoping for better deals, or, you know, the state's hoping the defendant's going to flinch first, you know, all the kind of stuff that may happen in normal circumstances. That's what I'm trying to front load and eliminate from the day of trial. Okay?
Yes, Judge.
All right. That takes care of Ms. Castelli, and I think that takes care of your docket, Mr. Morrison.
Does, Judge. Thank you, Your
All
Honor.
right, have a good day.
You as well.
Are we ready to recall Mr. Wilkins,
Yes, Your
who's our last inmate?
Your
Come on
Honor,
up, Mr. Wilkins.
Your Honor, we're also gonna maybe recall number one, Morgan.
Okay. Well, let's start with Mr. Wilkins. He's been sitting patiently all morning. So let's go ahead and swear Mr. Wilkins in.
You do solemnly swear or affirm the testimony you're about to give in this case is the truth, the whole truth, and nothing but the truth, so help you God?
Morning, sir. Tell me your name and your date of birth.
Edwin Michael Wilkins, 7/27/1990.
You can put your hand down, Mr. Wilkins. Sir, as you stand here, you're currently charged with 2 crimes. The first is driving with a license revoked as a habitual offender, a third-degree felony, punishable up to 5 years in prison. And the second is driving with a license suspended, having 2 prior convictions, a first-degree misdemeanor, punishable up to a year in the county jail, and it has a 10-day minimum mandatory sentence. Do you understand those 2 charges?
Yes, sir.
Mr. Carbone, on behalf of the defendant, how does he want to resolve his case?
Your Honor, at this time, my client would enter a no contest plea to count 1. The negotiated agreement is an adjudication of guilt, 24 months of supervised probation, 100 hours community service, credit time served of 46 days in the Osceola County Jail, the fact class, and court costs.
State, is this your agreement?
Yes, Your Honor.
Anything else, Mr. Carbone?
I believe the state has an announcement on count 2.
All right. I'll take that when I'm done with count 1. Mr. Wilkins, have you decided this is the best way to resolve your case?
Yes, sir.
As you stand here today, are you under the influence of any drugs, alcohol, or other medication?
No, sir.
Have you ever been treated for a mental illness, emotional disturbance? Are you suffering from such at this time?
No, sir.
Do you read and understand the English language?
Yes, sir.
Your attorney has given me a document called a plea form. I'm going to hold it up. I don't expect you to read it from here, but it's a 2-page document. It's got your case number on it, your name on it, the charge you're pleading to, the resolution, and all your rights. This document look familiar to you?
Yes, sir.
Did you go over this document with the public defender's office?
Yes, sir.
They explained to you all the rights you have and the rights you're giving up by entering this plea.
Yes, sir.
Did they answer any questions you had about your rights?
Yes, sir.
Did you then initial each paragraph indicating you read and understood it?
Yes, sir.
Did you sign on the last page?
Yes, sir.
Do you understand you're entering a plea today, which means there won't be a trial in your case and I will sentence you this morning?
Yes, sir.
Has anyone forced, threatened, or coerced you to enter this plea?
No, sir.
Other than what's been discussed here in open court, has anyone made any other promises to you about the sentence you would receive?
No, sir.
Are you satisfied with the work Mr. Carbone's done in handling your case?
Very satisfied.
Looks like he's gone the extra mile to make sure this is a legitimate resolution. Do you understand, sir, if you were not a citizen of the United States, entry of this plea would result in your deportation?
Yes, sir.
Mr. Bain, factual basis for count 1?
Your Honor, on February 7th of 2020, law enforcement observed a vehicle traveling at a high rate of speed and using a center lane to pass other vehicles. Center turning lane to pass all the vehicles. Law enforcement conducted a traffic stop. Discovered the defendant inside the vehicle did not possess a driver's license. The defendant only had an ID. He's been for his driving record, Judge, he's been labeled as a habitual traffic offender. His license has been suspended several times. All these things happen also in County, Florida.
Mr. Carbone, any objection to that factual basis for purposes of this plea?
No, Your Honor.
And are you satisfied that the current wording of the statute supports the determination the defendant has committed this crime?
Yes, Your Honor.
All right. Sir, I accept your plea. I find you alert and intelligent. Your plea is freely and voluntarily entered. You understand the nature of charges against you. You're represented by competent counsel, with whom you say you're satisfied. I also find a factual basis for the plea based on the presentation in court and the affidavit filed in the case. Is there any legal reason why sentence should not now be imposed, Mr. Carbone?
No, Your Honor.
All right. Mr. Wilkins, is there anything other than this case holding you in custody?
No, sir. I'm out on bond on 2 different cases.
Okay. All right, so the court having accepted your plea on count 1, I'm going to sentence you as follows. I'll adjudicate you guilty. I'll sentence you to 46 days in the Osceola County Jail with credit for the 46 days time served you have. That's going to be followed by 24 months of supervised probation. I'll order that you report to Department of Corrections probation no later than 4 p.m. tomorrow, Wednesday, June 10th, 2020. While you're on probation, I'll order within 45 days of today's date, you enroll in and complete a DWILIS FACT class. I'm going to order that you perform 100 hours of community service at a minimum rate of 8 hours a month. I'm going to order that you pay any statutorily required fines, fees, and costs associated with count 1. Madam Clerk, what would those be?
$415 court costs, a $3 teen court fee, $100 cost of prosecution, $100 PD lien, $100 PD assistance fee, for a total of $718.
Sir, any reason, if I gave you 60 days from your date of release, any reason you can't pay $40 a month towards your cost?
No, sir.
All right. I'll order within 60 days of your release from custody that you begin making payments at a minimum rate of $40 a month towards your cost until your costs are paid in full. I'll order that you pay that through probation as a condition of your probation.
Yes, sir.
State anything else on the count 1 sentence?
Now on count 1, Your Honor. I'll announce the null process to count 2, Your Honor.
Mr. Carbone, anything else on count 1?
No, Your Honor.
Madam Clerk, anything else on count 1?
No, sir.
That's the judgment and sentence of the court. Defendant may be released on this case only. Good luck to you, sir. All right. That takes care of that. Mr. Carbone, you wanted to recall a case off the morning docket earlier?
Yes, Your Honor. I've negotiated with ASA Bain, and he wants to offer credit time served in this case to the misdemeanor.
Tell me which case.
Oh, I'm sorry.
And a whiskey, Judge.
Number 1, Morgan Antuzeski, 20 CF 1361.
All right, let's swear her back in.
Raise your right hand, please. You do solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
All right, ma'am, tell me your name one more time. Ms. Anchesky, earlier this morning, I arraigned you on a 2-count information, possession of controlled substance, a 3rd-degree felony, punished by 5 years in prison, and count 2, possession of drug paraphernalia, 1st-degree misdemeanor, punished by up to a year in county jail. Do you remember that?
Yes, sir.
Your attorney is now telling me that you would like to enter a plea on count 2 with the understanding that the court would sentence you to 32 days in the Osceola County Jail with credit for 32 days time served, and the court would order that you pay any statutorily required cost for that misdemeanor offense. Is that your understanding?
Yes.
And Mr. Carbone, is that your understanding of the resolution?
Yes, Your Honor.
All right. And Mr. Bain, your offer on Ms. Anchesky is credit time served on count 2?
Yeah, adjudication of guilt, credit time served, that's count 2, Your Honor.
Okay.
Count count 1.
And Mr. Carbone, I'm guessing there's not paperwork filled out at this point in time?
No, Your Honor.
All right. So, ma'am, I just need to ask you a few questions. You understand that you're entering a plea today? Do you understand that means there won't be a trial in your case? You understand that means you're giving up your lawyer's opportunity to conduct any further investigation, raise any doubt about your guilt, file any motions. You understand all of that? You understand you're giving up right to have a jury hear the evidence and decide whether you're guilty or not? And have you decided it's in your best interest to enter this plea today and give all those rights up? Has anyone forced, threatened, or coerced you into this plea? Other than what's been discussed here in open court, has anyone made any other promise to you about the sentence you'd receive in this case? Are you satisfied with the work the Public Defender's Office has done in the limited time they've represented you? And again, you understand they're not going to do any further work on the case by the entry of this plea. Do you understand, ma'am, entry of this plea would result in your deportation? State factual basis for count 2?
Yes, Your Honor. On May 9th of 2020, law enforcement was on routine patrol. Observed a vehicle, failed to make a complete stop at a stop sign. Law enforcement made contact with the occupants of the vehicle. The defendant was the rear passenger of the vehicle. She had 2 active felony warrants out of Seminole and Orange County. Search into the lawful arrest, discovered a crack pipe and in her possession. The crack pipe field tested positive for cocaine. All these things happened in Osceola County, Florida.
Mr. Carbone, any objection to that factual basis?
No, Your Honor.
Ma'am, I'm going to accept your plea. I find you alert and intelligent. Your plea is freely and voluntarily entered. You understand the nature of the charges against you. You're represented by competent counsel with whom you say you're satisfied. I also find a factual basis for the acceptance of the plea. Is there any legal reason why the court can't impose sentence on count 2?
No, Your Honor.
All right, ma'am, the court having accepted your plea on count 2, I will adjudicate you guilty. I'll sentence you to 32 days in the Osceola County Jail. I'll give you credit for the 32 days you've already served. I'll order that you pay any statutory required fines, fees, and costs associated with this misdemeanor conviction. Madam Clerk, what would those be?
It's going to be $273 court costs, a $50 PD lien, $50 PD assistance fee, and a $15 paraphernalia surcharge for a total of $388.
Ma'am, if I gave you 60 days from your date of release, any reason you can't start making payments at a minimum rate of $30 a month towards your cost? All right. Order within 60 days of your release from custody that you contact the clerk of the court, set up a payment plan, and begin making payments at a minimum rate of $30 a month towards your cost until your costs are paid in full. State, do you have an announcement on count 1?
It's announced no process, count 1, Your Honor.
All right, Mr. Carbone, anything else?
No, Your Honor.
Madam Clerk, anything else?
No, sir.
That's the judgment sent to court. Ma'am, you're released as to this case only. Good luck to you. Mr. Ramjawan, how'd things go in your other courtroom?
It went well.
Okay.
Case got continued, actually.
Okay.
So,
All right. Are you ready to call up your case?
I kind of am. The defendant's family is downstairs and would like to just observe him be sentenced. I know times are different. I feel obligated to ask because this has never come before them.
What's the disposition of the case?
It's a jail sentence. Adjudication, 365 days in the county jail. They all have masks.
Well,
Yeah.
I am empathetic with that request. However, I feel like the Supreme Court has exercised its authority under a state of emergency to restrict access to the courthouse. And my reading of their order indicates that we should be restricting access to necessary parties and necessary witnesses, and only in circumstances where there's not a way to otherwise conduct the proceeding using technology, for lack of a better term. So,
It is 11 o'clock. Nobody's here. Courtroom's empty.
well, all I can suggest is there's at least one other circuit that's been in the media for apparently failing to follow the Supreme Court's guidance.
And I would not want this court to be in the media.
Well, and it's not,
Not because of something I did or requested.
and I don't raise that in the sense that I don't want to be in the media. I raise it in the sense that I suspect the Supreme Court may end up in some way making some comment on about judges not following their guidance and how important it is to follow the guidance. So, again, I understand the request, but I'm going to deny the request at this time because I think if I ordered that they be brought in, that would violate the current guidelines from the Supreme Court and the Supreme Court's current order. So,
Would the court be okay with a report date?
what's he pleading to?
Importation. He scores 22 points on his score sheet. No prior history.
What's the charge he's pleading to?
Importation?
Trafficking in 400 grams or more of cocaine, 15-year minimum mandatory.
Okay.
Oh,
What's the actual agreed upon sentence?
It's a plea to lesser included importation of cocaine, 365 days in Osceola County Jail.
So there's not a minimum mandatory.
No, Judge. But if he decides that he wants to then walk away, then that may not be the case. And then we'll be back here trying him for a 15-year amendment.
All right. So, Mr. Bain, I guess the question is, what's your position on the defendant entering his plea today and coming back for sentencing?
Not with this case, Judge, just because of the potential of him, like me losing him and then having to come back to try him for a 15-year man, doesn't really appeal to the judicial ethics, Judge.
Okay. Because it was a plea to a lesser, I think my ability to, I think if the state objected, I can't force him to offer a lesser, and it sounds like the state's not willing to do it. I don't know what I would have decided ultimately, but the state's.
I think it's in his best interest that he goes in today and nothing bad happens because he's looking at a 15-year man on it.
I understand that. All right, let's go ahead and have him come up. Go ahead and swear him in.
Raise your hand, please. You do solemnly swear or affirm the testimony you're about to give in this case is the truth, the whole truth, and nothing but the truth, so help you God?
All right, sir, you need to answer in a loud voice.
Okay.
Okay. Sir, tell me your name and your date of birth.
Oscar Castillo, date of birth, January 23rd, 1996.
All right, Ms. Castillo, I want to talk to you about the charge you're currently facing, and then my understanding of the resolution, so just listen carefully. Right now, you're charged with one crime. The crime you're currently charged with is trafficking in 400 grams or more of cocaine. That's a first-degree felony. It's punishable up to 30 years in prison, and there's a 15-year minimum mandatory sentence associated with that. Do you understand that charge?
Yes, sir.
Do you understand the maximum sentence?
Yes, sir.
Do you understand the 15-year minimum mandatory?
Yes, sir.
Your attorneys indicated to me that he has negotiated a resolution where you would plead to a lesser included offense of importation of cocaine, a second-degree felony, punishment of 15 years in prison, and there would be no minimum mandatory sentence associated. Do you understand that?
Yes, sir.
Have you decided that that's how you want to resolve your case?
Yes, sir.
Okay. You've been present in the courtroom when your lawyer asked me about ordering that your family be allowed to come upstairs to watch you enter this plea and watch you be remanded to custody. Were you present for that discussion?
Yes, sir.
Okay. And do you understand, in normal circumstances, you could fill this gallery with all the friends and family you wanted to watch. Unfortunately, we currently don't live in normal circumstances, and many of the public access things that we normally had in place have been suspended because we're trying to make sure that people can come to court and that the people who work here and the people who come here don't end up getting exposed to coronavirus or having other issues.
Understood.
There was also discussion about the possibility of a report date or a comeback date for sentencing. The state's objecting to that. Do you understand that?
Yes, sir.
And understanding all that, have you decided the best thing to do is just proceed forward today, enter your plea with the understanding that I will sentence you and remand you to jail today?
Yes, sir.
All right. Mr. Ramjuan, can you go ahead and just announce again what the proposed resolution is on the plea to the lesser?
The defendant would like to plead no contest to a lesser included charge of importation of cocaine. The state's offer is an adjudication of guilt, 365 days in the Osceola County Jail and court costs.
All right. State, this is your agreement, correct?
Yes, Your Honor.
All right. And Mr. Castillo, this is how you want to resolve your case, correct?
Sir.
As you stand here today, are you under the influence of any drugs, alcohol, or other medication?
Sir.
Have you ever been treated for a mental illness, emotional disturbance? Or are you suffering from such at this time?
Yes, sir.
Do you read and understand the English language?
Yes, sir.
Your attorney has given me several documents. One's a plea form. It's a 2-page document printed front and back. The other is a notice of appeal rights form, 1-page document. Both of them have your name on it. Actually, Mr. Ramjuan, the notice of appeal rights does not have the style of the case or case number on it, although I think it's basically covered in the plea form. So I'll give you that document back. Sir, did you go over this plea form with Mr. Ramjuan?
Sir.
Did he explain to you all the rights you have, the rights you're giving up by doing this plea?
Yes, sir.
Did he answer any questions you had about your rights?
Yes, sir.
Did you then go through the form initially in each paragraph indicating you read and understood what was explained in the paragraph?
Yes, sir.
Did you sign on the last page?
Yes, sir.
Do you understand that you are entering a plea today, which means there will not be a trial in your case, and I will sentence you this morning?
Yes, sir.
Has anyone forced, threatened, or coerced you to enter this plea?
Yes, sir.
Other than what's been discussed here in open court, has anyone made any other promise to you about the sentence you'd receive in your case?
Yes, sir.
Are you satisfied with the work Mr. Ramjuan has done in handling your case?
Absolutely.
It looks like he got you a pretty good outcome, sir. Do you understand, sir, if you were not a citizen of the United States, entry of this plea would result in your deportation?
Yes, sir.
State factual basis for the lesser included?
Yes, Your Honor. On February 12th of 2020, law enforcement received information that a package arriving from Puerto Rico into Osceola County, Florida, may be containing narcotics. Law enforcement intercepted the package that had been addressed to Marta Gonzalez. K-9 alerted to the package. Law enforcement with the legal postal service agents didn't make a controlled delivery of the package. Law enforcement officer and the agent met the defendant at the door. He said that Marta was not home, but would accept the package. Post Miranda, the defendant admitted that he was aware the package contained cocaine, that it was the third package he had received for money. The contents of the package contained a little over almost 2 kilos of cocaine. All these things happened in Osceola County, Florida.
Any objection to that factual basis for purposes of this plea, Mr. Ramjuan?
No, Your Honor, not for purposes of the plea.
All right, sir, I'm going to accept your plea. I find you alert and intelligent. Your plea is freely and voluntarily entered. You understand the nature of the charges against you, and you're represented by competent counsel with whom you say you're satisfied. I also find a factual basis for the plea to the lesser included offense based on the presentation in court and the affidavit filed in this case. Mr. Ramjuan, is there any legal reason why a sentence should not now be imposed?
No, Your Honor.
Is your client waiving a pre-sentence investigation?
He does.
All right. Mr. Castillo, the court having accepted your plea as to the lesser included offense, I will adjudicate you guilty. I will sentence you to 365 days in the Osceola County Jail with credit for 2 days' time served. I'll order that you pay any statutorily required fines, fees, or costs associated with this conviction. Mr. Bain, is there a statutory specified fine amount for the lesser?
No, Your Honor.
All right. Madam Clerk, can you announce all of the statutorily required fines, fees, and costs?
Yes, sir. It's going to be $415 court costs, a $3 teen court fee, $100 cost of prosecution, and a $350 drug case fine for a total of $868.
Mr. Castillo, if I gave you 90 days from your release from custody, any reason you can't pay that amount in full?
No, sir.
All right. I'll order within 90 days of release from custody that you contact the clerk of the court here in Osceola County and pay your cost in full. State, anything else?
No, Your Honor.
Mr. Ramshawn, anything else?
No, Your Honor.
All right, Mr. Castillo, you're remanded to the custody of the Osceola County Jail at this time to serve the balance of your sentence. Good luck to you, sir.
Yeah, Your Honor, it's fine. You gotta get printed.
All right, I believe that is the docket for the day.
Judge, as an unrelated matter, in order for us to resolve more cases,
Court accepting plea conference.
You are here for an initial appearance after detention. The rules of criminal procedure require that you be brought before a judicial officer within 24 hours of your arrest. The purpose of the initial appearance is to have a judge list the charges against you, inform you of certain rights that you have, and to determine the conditions of your release. You should have already received a copy of these charges. The judge will review your paperwork to determine if there was probable cause to arrest you. If the judge finds probable cause, he or she will then determine if you qualify for bond and what the monetary and non-monetary conditions of your bond should be. If the judge does not have enough information to make a probable cause determination for your arrest, the state may be given additional time to amend the paperwork. You should also be aware of the following rights afforded to you by the Constitution. You are not required to say anything at this proceeding. Anything you say can be used against you. You have the right to communicate with counsel, family, or friends, and if necessary, you will be provided a reasonable means to do so. You have the right to counsel. If you have not already retained counsel and cannot afford counsel, the judge will appoint you a public defender. For the purposes of today's initial appearance proceedings, you may be able to briefly speak with a public defender regardless of whether the public defender is appointed for you. In order to have an attorney appointed by the court to represent you, you must be financially eligible, as determined by the court based on financial information you provide. Therefore, if you have not already done so, please complete, to the best of your knowledge, the financial affidavits provided by the correction officers. An application fee for the services of appointed counsel will be assessed. If you do not speak English or Spanish, please let a corrections officer know. When the judge is ready, she or he will begin calling your case by name. Please listen carefully for your name. When called, please approach the microphone as directed by the corrections officers. Thank you.
Usted se encuentra aquí para una audiencia o vista preliminaria, después de haber sido arrestado. Las leyes y estatutos criminales del estado de la Florida requieren que se celebre una vista preliminaria ante un oficial judicial dentro de un plazo de 24 horas después de su arresto. El propósito de esta vista preliminaria es para que el juez pronuncie los cargos contra usted, para que se les comunique a usted sus derechos procesales y para determinar las condiciones de su libertad o fianza. Ya usted debería haber recibido una copia de estas alegaciones o acusaciones por escrito. Ahora, el juez revisará la documentación en su caso para determinar si existe motivo fundado o causa probable para su arresto y detención. Si el juez determina que existe causa probable o motivo fundado, entonces decidirá si usted califica para que se le otorgue una fianza, tanto como cuáles serían las condiciones monetarias o no monetarias de dicha fianza. Si el juez no posee suficiente información para determinar si existe causa probable o motivo fundado para justificar el arresto, se le concederá a la Fiscalía tiempo adicional para modificar la documentación. También se les avisa que posee los siguientes derechos que se les otorgan por la Constitución. A usted no se le puede obligar a decir nada durante esta vista. Cualquier cosa que diga podrá ser utilizada en su contra como evidencia. Usted tiene el derecho de comunicarse con un abogado, pariente o amigo, y si es necesario, que se les proporcione los medios razonables y disponibles para hacerlo. Usted tiene el derecho a un abogado. Si todavía no ha encontrado o contratado un abogado y no tiene los recursos para hacerlos, entonces el juez le nombrará un defensor público. Para el propósito de la audiencia preliminaria de hoy, se le permitirá hablar brevemente con un abogado de la Oficina del Defensor Público, aun cuando no se le haya nombrado para representarle en todo el caso. Para poder recibir la designación de un abogado, primero debe calificar económicamente según lo determine el juez. Esto será basado en la información financiera que usted proporcione aquí. Por lo tanto, si no lo ha hecho todavía, de la mejor manera posible, por favor, llene el formulario de insolvencia económica que se le ha proporcionado por el oficial de correcciones. Se le impondrá un recargo o costo por los servicios del defensor público. Si usted no habla inglés, por favor, hágale saber al oficial de correcciones. Cuando esté listo, el juez comenzará el proceso llamando a cada una persona y caso por su nombre. Por favor, esté pendiente para pasar adelante cuando escuche su nombre y cuando escuche su nombre, haga el favor de acercarse al micrófono, tal como le indique el oficial de correcciones. Muchas gracias por su atención.
All right. You cut the musical interlude a little short.
It just replays the beginning again.
Good afternoon, this is a Spanish interpreter.
All right, we are here for initial appearances. The folks will not have headsets on, so please come forward. Monica Blanco. All right, Ms. Blanco, if you'll please state your name. And interpreter.
Por favor, indique su nombre.
Mónica Blanco.
Monica Blanco.
All right, Ms. Blanco, you were arrested on a charge of battery.
Señora Blanco, a usted le arrestaron por una acusación de agresión física.
The public defender's office is appointed to represent you.
Se le está designando un defensor público para representarle.
The court does find probable cause that you committed this offense based on the arrest affidavit.
Basado en el informe de arresto, se determina en este juzgado que existe suficiente fundamento para sustentar el arresto.
Your bond is presently set at $0.
En este momento dado no tiene derecho a fianza.
Does pretrial release have any history?
I'm sorry, Your Honor, I can barely hear. There's so much background noise.
All right.
She has no prior criminal history and the victim is requesting no contact.
I'm sorry, Your Honor, the interpreter cannot hear.
The defendant has no prior criminal history and the victim is requesting no contact.
La acusada no tiene antecedentes penales previas y la víctima está pidiendo que no haya ningún tipo de contacto.
Ms. Blanco, I'm going to set your bond in the amount of $500.
Señora Blanco, la fianza se va a fijar en $500.
It will be conditioned upon supervision.
Wait,
It will be conditioned upon supervision by pretrial release.
y será con la condición de que el programa de libertad provisional le supervise.
If you do postpone, you will not have any contact directly or indirectly with Luis Enrique Sanchez La Antigua.
Y si logra usted salir bajo fianza, estará usted prohibido tener un tipo de contacto, sea directo o indirectamente, con Luis Enrique Sánchez Antigua.
You will not return to the area of his, where he is residing.
Prohibido regresar a la zona donde él está residiendo.
You may do so on one occasion accompanied by a law enforcement officer to retrieve any clothing or personal possessions you have at that address.
Y se le permitirá a usted regresar a esa dirección solo una vez, acompañada por un agente policial para recoger sus pertenencias.
You will not possess any weapons or firearms.
Prohibida la tenencia de armas o armas de fuego.
Your next court date will be
Next court date, if still in jail, June 18th. If out, July 13th in courtroom 5B at 9:30 a.m.
La próxima vista, si sigue encontrándose usted en la cárcel, será el 18 de junio. Si no, la siguiente vista será el 18 de julio en la sala 5B a las 9:30 de la mañana.
Thank you.
Gracias. I'm sorry, Your Honor. Could the interpreter have the case number?
Yes, 20 MM1370. And next we will have 20 MM1375, Salene Rivera. Tell us your name, please.
Diga su nombre, por favor.
Sailin Ramos Rivera.
Sailene Ramos Rivera.
Ms. Ramos Rivera, you were arrested on a charge of battery.
Señora Ramos Rivera, a usted la arrestaron por una acusación de agresión física.
The court finds probable cause that this offense was committed based on the arrest affidavit.
Basado en el informe de arresto, se determina que existe indicios de criminalidad, que tal ilícito sí se cometió.
The public defender's office is appointed to represent you.
Se le designa defensor público para representarle.
Your bond is presently set at $0.
En este momento dado no tiene derecho a fianza.
Do we have any prior criminal history?
¿Acaso ya tiene antecedentes penales?
The defendant has 3 prior arrests, driving with license suspended with knowledge, no vehicle registration, and a failure to appear on that case, and the victim is requesting contact.
La acusada tiene 3 arrestos, uno por conducir con licencia suspendida manifiestamente, por no tener el permiso de circulación para el vehículo, una falta de comparecencia, y la víctima sí está solicitando tener contacto.
Ms. Ramos Rivera will set bond in your case the amount of $500.
Señora Ramos Riveras, en su caso dado, la fianza se fijará en $500,
It will be conditioned upon supervision by pretrial release.
con la condición que usted sea supervisada por el programa de provisional.
Based on the alleged facts, until further order of the court, you were ordered not to have contact with William Melendez Maldonado.
Basado en los hechos y al menos que haya una orden posterior que lo cancele, usted está prohibido tener ningún tipo de contacto con William Melendez Maldonado. Thank you, Your Honor.
You are not to return to the area of 2230 Cascades Boulevard.
Prohibida regresar a la zona del 2230 Cascade Boulevard.
You may return on one occasion accompanied by a law enforcement officer to retrieve clothing or personal possessions you have at that address.
Se le permitirá una vez regresar a la residencia para recoger sus pertenencias con tal que sea acompañado por un agente policial.
Until further order of the court, you're going to have to find another place to stay.
Hasta que tenga una orden judicial que indique lo contrario, usted tendrá que conseguir otro lugar donde vivir.
You will not possess or consume any alcoholic beverages or any controlled substance without a valid prescription.
Prohibida el consumo o tenencia de bebidas alcohólicas o sustancias reguladas, al menos que tenga receta médica.
You will not go to any bars, clubs, or other places whose primary source of income is derived from the sale of alcoholic beverages.
Tampoco permitirá entrar a bares o cantinas donde el negocio principal es la venta de bebidas alcohólicas.
You will not possess any weapons or firearms.
Prohibido la tenencia de armas o armas de fuego.
Ms. Ramos Rivera, the conditions can be modified when the court receives additional information.
Señora Ramos Rivera, las condiciones podrán ser modificadas con tal que este juzgado reciba información adicional.
You can talk to your lawyer about trying to obtain a modification if you want to have contact and if you want to return to the residence.
Si usted desea regresar a la residencia o tener contacto con la víctima, tendrá usted que hablar con la abogada para ver si pueden hacer cambios a esas condiciones.
But until or unless an order is entered by the court, you cannot have contact with Mr. Maldonado.
Pero al menos que una orden judicial indique lo contrario, usted estará prohibida tener contacto con el señor Maldonado,
Even if he wants to have that contact.
aun si él mismo desea tener contacto con usted.
So talk to your lawyer as soon as possible to try to arrange for that modification if that's what you want.
Hable con su abogada tan pronto posible para que haga los arreglos para poder conseguir esa modificación si eso es algo que le interesa a usted hacer.
Your next court date will be
Next court date, if still in jail, June 18th. If out, June 30th in courtroom 4A at 8:15 a.m.
La próxima vista, si todavía se encuentra en la cárcel, es el 18 de junio. Si no, será el 30 de julio a las 8:15 de la mañana en la sala 4A.
Thank you.
Gracias.
Does anyone else require the services of the Spanish language interpreter? If so, please come forward at this time.
¿Hay alguien más que requiere una traductora en español? Si es así, por favor, acérquese.
Okay. Thank you, Madam Interpreter.
You're welcome, Your Honor. The interpreter will disconnect.
Derek Westbury? All right. Good afternoon, sir. State your name, please.
Gary Westbury.
Mr. Westbury, you were arrested on a warrant out of Polk County for 3 counts of petty theft as a third or subsequent offender and 1 count of obtaining property by fraud. Your bond was set at $1,000 as to each count for a total of $4,000. If you post that bond, you'll be released pending your next court date in Polk County. If you do not post bond, you'll be held until Polk County comes to pick you up. Normally, that would be within a couple of days. I don't know right now, given the pandemic situation, how frequently or whether they're picking up folks from Polk County. We will contact the court in Polk County to see if they would be suggesting any modification of your bond because of the present situation. The Public Defender's Office is appointed to represent you while you remain in the Osceola County Jail. If you post bond or later are transported to Polk County, a lawyer will be appointed to represent you in Polk County at your next court appearance. So the Public Defender's Office can also look into this to see if it would be appropriate to reduce or modify the conditions of release. Thank you, sir. Thank you.
So I'm gonna get post my bond today.
So yes, you can post bond if you're able to, and you'll be released once you do so. Thank you. Jaime Guevara Rivera.
Yes, Your Honor.
Good afternoon. State your name, please.
Jaime Isaac Guevara Rivera.
Mr. Guevara Rivera, you were arrested on a warrant charging you with burglary to a structure, grand theft, 3 counts of dealing in stolen property, and 3 counts of obtaining property from a pawnbroker by false verification of ownership or identification. Your bond is set at $2,500 for the burglary, $2,000 for the grand theft, and $150 for each of the other accounts, for a total of $5,400. The Public Defender's Office is appointed to represent you in this case. Your next court date will be on demand in circuit court. Thank you, sir.
Judge, as it is one has conditions of no return to the scene, no contact with the victim or witnesses.
Right, all conditions will remain as such.
Yes, sir.
Michael Anderson. State your name, sir.
Michael Anderson.
Mr. Anderson, you're arrested on a charge of battery. Your bond was set at 0. And in your case, and folks, for all the cases, unless I indicate otherwise when your name is called, I do find probable cause to believe that you committed the offense for which you've been arrested based on the arrest affidavit. And that is true in your case, Mr. Anderson, as well. The Public Defender's Office is appointed to represent you. Your bond is presently set at 0. Do we have any information on Mr. Anderson?
The defendant has arrest going back to 2018, possession of marijuana, has an open case out of Bay County for burglary of an unoccupied dwelling, grand theft, 2 counts of grand theft. I'm sorry, that's Calhoun County. There's a notice to appear for that case. Has an open case out of Bay County.
I'm sorry, can PTR get closer to the mic?
The defendant has 2 open cases, one in Calhoun County for charges of burglary of an unoccupied dwelling and 2 counts of grand theft. There's a notice to appear for that. And an open case out of Bay County for charges of harvest, destroy, or transport endangered plants. And we were not able to contact the victim today, Judge.
Okay, and those are in Wisconsin, the two?
I'm sorry, Judge?
The 2 other open cases are in Wisconsin, or are they here? Or?
They seem to be local, Judge.
All right, Mr. Anderson, where do you live, sir?
Sir, I'm from Wisconsin, Milwaukee, Wisconsin, but from my knowledge, none of that's true. I've never been to Dade County or the other county he said.
Okay, that may not be, sometimes names, Mike Anderson's not a real unusual name. Sometimes information may get jumbled. Okay. Mr. Anderson, now I see on the paperwork here that it says other legal constraint, but it looked like there was writing there that was whited out. Do you think that?
We've been told, that this is the information that I gave you, Judge. If it's another county, we've been told not to write it in this form because it's sensitive information. And this form is via email and it's not secure. So we're no longer writing information from another counties in this form.
Okay.
But the information that I gave you on these open cases is what was supposed to be there.
Okay. So because of that, he wouldn't qualify for pretrial?
That's correct, Judge. He wouldn't qualify for PPR.
All right, Mr. Anderson, I'm going to set bond in the amount of $1,000. The bond will be conditioned upon you not having any contact directly or indirectly with either Jacala Bowman or with Shamaria Walton. You will not return to any residence where they are located. If you have personal property at a residence where they are staying, you will be allowed to return accompanied by a law enforcement officer, pick up your clothing or personal possessions. You will not possess any weapons or firearms. The Public Defender's Office is appointed to represent you. The conditions of release can be modified later by the court once more information is obtained, so you can talk to your attorney about the possibility of doing that. Your next court date will be?
Next court date, if still in jail, June 18th. If out, July 13th in courtroom 4A at 9 a.m.
Thank you, sir. All right, Pierre Brinson,
Responded, Your Honor.
okay, thank you. Sarah Hartman, state your name, please.
Sarah Hartman.
Ms. Hartman, you're arrested on a charge of driving while under the influence resulting in property damage. You have a bond set of $1,000. Are you going to be able to post that bond?
I can post the percentage, but I can't give a phone number to the bondsman because my phone is in my car.
Your Honor, we're asking if we can do direct PCR.
What's the prior history? Right, I see that. What's the prior history?
She has one prior arrest in 2010 for a DUI. She was found guilty. That is all.
On a second DUI, I'm not going to agree to direct pretrial release. Ms. Hartman, I'm going to leave the bond at this time in the amount of $1,000. The public defender's office is appointed. They may be able to assist you in communicating with whoever you need to communicate with outside of jail. Your next court date will be?
Next court date is still in jail, June 18th. If out, July 1st in courtroom 4E at 8:15 a.m.
Thank you. Gustavo LeBron. State your name, sir.
Gustavo LeBron.
Mr. LeBron, you're arrested on a charge of battery. Your bond was set at 0. It's a case in which both parties were arrested, I guess. The public defender's office is appointed to represent you. Do we have any prior history on this?
He has no prior history.
All right, and is he requesting contact with the,
Yes, Judge, both victims are requesting contact with each other.
all right, based on the factual allegations in this case, I will set bond the amount of $100. It'll be conditioned upon supervision by pretrial release. Further conditioned upon you not having any hostile contact with Paola Marie Miranda Otero, or that you not possess or consume any alcoholic beverages or controlled substance without a valid prescription, not possess any weapons or firearms. If you can't get along, you need to just leave the area. Otherwise, you'll wind up sitting in jail with no bond until the case is resolved. Your court date will be?
Next court date is still in jail, June 18th. If out, July 7th in courtroom 4E at 8:15 a.m.
Okay, Courtney Lakudinoy, and this is another situation where I think both folks are arrested. State your name, please.
Good afternoon, Your Honor. My name is Courtney Lecatano.
I'm sorry, how do you say your last name?
Lecutano, it's quite a mouthful. My apologies.
Lakatanoy?
Yes, sir.
Okay. Ms. Lakatanoy, I'm sorry, you're arrested on charge of battery. Your bond is set at 0. The public defender's office is appointed to represent you. I see the other party does want contact. Any prior history on this?
No prior history on the defendant.
Okay, ma'am, I'm going to set your bond in the amount of $100. It will be conditioned upon supervision by pretrial release. If you do post bond, and assuming Mr. Richmond is released, it will be conditioned upon you not having any hostile contact with Malik Richmond. You will not possess any weapons or firearms.
No, sir.
You will not possess or consume any alcoholic beverages at all,
No,
or any controlled substance without a valid prescription. You will be subject to testing. Your next court date will be?
If still in jail, June 18th. If out, July 1st in courtroom 4E at 8:15 a.m.
Thank you, Your Honor. God bless you.
Sorry. Yeah, be subject to random testing. Paola Miranda Otero. All right, state your name, please.
Paula Miranda.
Ms. Miranda, you're arrested on charge of battery. Your bond was set at 0. Any prior history?
No priors, Judge.
Okay. Ms. Miranda, I'm going to release, order, set bond in the amount of $100, which will be conditioned upon supervision by pretrial release. Will be further conditioned upon you not having any hostile contact with Gustavo LeBron. There's no pushing, no shoving, no biting, no scratching, no hair pulling. You get the picture. You will not possess or consume alcoholic beverages or controlled substances without a valid prescription. You'll be subject to random testing to ensure that that is complied with. You will not possess any weapons or firearms. The public defender's office is appointed to represent you. They will likely withdraw from one of your cases. If they do that, and another lawyer will be appointed to represent you. Your next court date will be
If still in jail, June 18th. If out, July 8th in courtroom 4E at 8:15 a.m.
Thank you, Your Honor.
Thank you. Rose Miles,
Hi, Your Honor.
good afternoon. State your name, please.
Rosemary Bowles.
Ms. Miles, you're arrested for failure to register email, address, or instant messaging name. The court does not find probable cause based on this affidavit. It doesn't indicate that she falls in a class that's required to do such registration. I'll give the state 24 hours to provide a supplemental affidavit if they choose to do so. But even so, you are entitled to a bond being set.
Thank you, Judge Morgan.
So I'm going to set bond in the amount of $1,000 as to each charge. Are you going to be able to post that bond?
Yes, I have 30 bonds in my mind.
Okay.
Judge Morgan, thank you.
Well, if you, I'm sorry, are you represented by Mr. Mullins, did you say?
Yes.
Okay, so I will not be appointing the public defender's office in your case.
Thank you very much.
Now, Ms. Miles, a couple of things. First, if you post bond, that's great, you'll be released. If you are unable to post bond, we'll see you tomorrow and see if the state has additional information. Secondly, talk with your lawyer.
Yeah.
You need to remedy whatever you're able to remedy as
Yeah.
quickly as you can.
Yeah, he's
So,
trying to take care of stuff
don't
next
s-
week and this week, so that
All
way
right,
he's
don't
trying to
say
get
anything else
everything
about
taken care
the
of.
facts of your case. Your next court date will be on demand in circuit court unless we see you tomorrow in the event you don't bond.
Oh, I will bond. It might not be today or tomorrow, but it'll be probably Friday or next week. Is that all right, Your Honor?
As far as bonding out,
Yeah, I guess, yeah, I still be able to bond out.
you can bond out whenever you wish.
Okay,
It's,
'cause
you
he
can do
told
that
me-
today or tomorrow or whenever you want.
I gotta call him when I get back to the pot, and he told me to call him, let him know what you're doing and stuff, so that way, because he's trying to get the misdemeanor that I have when I call the cop.
Okay.
Just for what we saw.
So I'm not gonna say nothing, I call him nice and quiet. Yes, he's fixing that where I can go out on bond too, so I have two bonds.
Oh.
This bond and that bond.
I'm sorry, Ms. Miles, from what pretrial release is telling me, I didn't get any paperwork on that, but you may have other issues that will keep you in. So if that's the case, just contact Mr. Mullins. He can take appropriate steps.
Yes, Judge Morgan, and thank you.
Thank you.
Thank you so much.
Malik Richmond. All right, state your name, sir.
Malik Richmond.
All right, Mr. Richmond, you arrested for battery. Your bond was set at 0 on that charge. You were also arrested for violation of probation in Orange County, case 17 CF 8753, in charge of grand theft. And your bond is set at 0 in that. I'm going to, based on the factual allegations, set bond on the battery in the amount of $100. It will be conditioned upon you not having any hostile contact with Ms. Courtney. I say Courtney Lee here, but it's actually Courtney Kudanoy. And it'll also be conditioned upon you not possessing or consuming alcoholic beverages or possessing any weapons or firearms. On the violation of probation, do we have prior history other than the grand theft?
Just that, charge that he's on probation.
Can PTR get closer to the mic, Your Honor?
I'm sorry?
Can PTR get closer to the mic? We can't hear him.
The only arrest is the arrest that he's out on probation for.
Okay, Mr. Richmond, I'm going to go ahead and set bond on your violation of probation, the amount of $1,000. Your next court date on the battery will be,
If still in jail, June 18th. If out, July 13th in courtroom 4A at 10:30 a.m.
all right, thank you, sir.
Thank you.
That was June 18th or June 8th?
Or,
June 18th
18th.
for jail arraignment. If out, July 13th.
all right, Miami Santos. All right. State your name, please.
Oh, sorry. Miami Santos?
Santos, you arrested on charges of resisting an officer with violence, battery on a law enforcement officer, battery on a person 65 years of age or older, and tampering with a witness in a third-degree felony proceeding. I don't find any, unless I'm missing it. I don't see the allegation of Miss Santos's age in the affidavit. So I will find probable cause on the, as to battery only, as to offense involving Ms. Santos. Your bond is presently set at 0 on the two domestic charges, of $1,000 on resisting and $2,500 on the battery. What prior history, if any, do we have?
The defendant has history going back to 2017, charges of possession of cocaine, drug paraphernalia, failure to appears in 2018. His last arrest here locally came in February 2020. Domestic battery, that was no problem. It was a different victim. Has history in Kentucky, Massachusetts, Virginia, Texas, and Georgia, with charges of domestic assault and domestic battery. That is all, Judge.
All right. Mr. Santos, I'm going to set bond on the battery charge in the amount of $500. On the tampering with a witness charge, I'll set bond in the amount of $500. Your bond in this case will be conditioned upon supervision by pretrial release. That will be conditioned upon you not having any contact pending further order of the court with Martha Santos. You will not return to the area of 1313 Mariana Way in Poinciana. You may do so on one occasion accompanied by a law enforcement officer to pick up clothing or personal possessions you have at that address. You'll need to find another place to stay on a temporary basis. You will not possess or consume any controlled substance without a valid prescription or alcoholic beverages. You will be subject to testing to ensure that you comply with that. You will not possess any weapons or firearms. The public defender's office is appointed to represent you. Your next court date is on demand in circuit court.
Excuse me, Your Honor, was there a bond set for the resisting charge?
The resisting is 1,000.
Okay.
The battery, Leo's 2,500. The other two are 500 each. Thank you, sir. I think that's all we had. Yeah. Yeah, we talked about that this morning. Thank you. Appreciate it. Did you have anyone we didn't call?
I had two. Pierre Brinson. I thought they said they were
Brinson bonded.
he bonded, and then Francisco Giovanni.
He bonded.
Perfect.
Thank you. Have a great afternoon.
Thank you.
Thank you.